as we mentioned in chambers, he's also secondhand man to his. On August 25th. His next clear trial setting is October 6th, which of course, you know, I intend to communicate with his public defender over there as to whatever decision is made today. However, my client would respectfully request you consider continuing him on community control, allowing him the opportunity to live and work and participate in the case in Butler County that we spoke of in chambers.
Mr. Ray, anything that you want to tell me?
No, she summed it up.
Mr. Ray, I'll continue you on probation if you want me to. Put you back into drug treatment and get all of that stuff dialed up. That means you have to go to a place like STAR or CCC for the next 4 to 6 months. The alternative to that is to do an additional 60 days in jail and be done with it. I assume you want to do the additional 60 days, right?
I do, sir.
All right. Court finds you have violated the terms of your supervision. I'm going to order that you serve 114 days in the county jail, credit you with the 54 days that you have already done. You have 60 days left to do. I will make you eligible for the litter pickup program. So if you want to go out with the litter crew, you will get an additional day of jail time credit for every day that you do with them. You are still on community control for the time that you're in the jail. So if you get in a fight, get caught with drugs, any of those kinds of things, I could still impose the maximum penalty in this case, which is 12 months in prison. All right, that's all.
Thank you, Your Honor.
Can I ask you one thing?
Sure.
Do you send a letter to the jail saying that I'm eligible for the work or the litter pickup
Yes.
without me requesting it?
Yeah, I mean,
I know a lot of people have to request it.
generally speaking, the litter crew is looking for people and they find you within a couple of days.
Okay. Thank you, sir.
Okay. All right, that's all.
Okay, hold on to your stuff. Okay, I'll let you know where you're at.
Please do.
All right. All right, Robert, good luck.
Charge. 150 is your total, okay? Cash your end of the hall to your right. Have a good day. Joshua Benjamin Camilleri, 25T646274. Good morning, your name?
Joshua Camilleri.
All right. Got to be careful, okay?
Yes, sir.
You're going to plead to impede him?
Yes, sir.
Responsible and not responsible to that.
Responsible.
All right, I'll accept the plea. 175, cash your end of the hall to your right, okay?
Thank you very much.
Good day. Thomas Robert Blisman, 25W706462. Good morning.
Good morning, Your Honor.
Do you have a lawyer here today with you?
No.
Your name?
Thomas Robert Blisman.
So forgive me, I'm not sure why you're here.
Well, I think that my sentencing was back in May. You said I had to review my case in 4 months. I'm in sobriety court.
Why no?
Right, so that's
Oh, every 4 months for court to determine if defendant should have to serve jail term. Who's your probation officer again?
James. Cedric James.
Yeah, have a seat 1 second. Can you send Sadie in here, please, on Tom Blisman? Okay, no problem. Thanks. S&D Investors LLC versus Ladero Garner, 2501355.
Good morning, Your
Good
Honor.
morning.
Zoom, Dan Goldman, 64231 plaintiff's attorney, present.
All right. Your name, sir?
Excuse me.
You have to unmute. You have to unmute, Mr. Garner.
Yes,
Okay, your name, sir?
Ladero Garner.
So the way I left it last time is that defendant was to file an amended complaint within 21 days. Is that right, Mr. Goldman?
No, Your Honor, answer. He was
Amended
to
answer.
file,
I'm sorry, I
Yes.
misspoke. My apologies.
and Your Honor,
Filing-
sorry.
Go ahead.
Yes, Your Honor, he was to file an amended answer. We had pretty good discussion about the details of the complaint and how we were entitled to know those details. He filed an answer, and Your Honor, it's substantively no different than what he filed before. We considered it a letter answer. I haven't had time to file a motion to strike, but Your Honor, if you look at, for instance, the second line of the answer that he filed, mine's dated August 29. He says, I denies the allegation.
Let me find it. Let me find it, please.
Yes, sir. August 29 was file date.
Linda, do you have something for me here?
Yes, I do have it, Judge. I'm sorry I didn't make it in that packet.
Maybe
I'll
you
have
did.
someone run it down.
Okay, do that and I'll recall
Yeah.
the case. Okay,
Okay.
thanks. I'll recall the case. Lombard, Janice Lombard, Janice Allen Lombard,
At the end,
25G646206. Come on up, man. Your name?
Janice Lombard.
Okay, so you're going to plead impeding traffic. They're going to dismiss the failure to yield causing accident. True? So there's no injuries, minor damage to the charge impeding traffic, responsible or not responsible. I'll accept the plea 195. Cash your end at the hall to your right and you're all set. Have a good day. Be calling Thomas Robert Blisman, 25W706462. Your name, sir?
Thomas Blisman.
Elizabeth Prosecution, Your Honor.
So I'm going to just find out what's going on here first. I told him to appear for review hearing every 4 months for court to determine if the defendant should have to serve the jail term that was imposed. I gave him 90 days in jail, and I said it was to be deferred. He was to serve 4 days of community service, 6 days court work, and pay $210 for that. And I deferred the 90 days jail. Is that what we're here for?
Yes, Your Honor.
Hmm. This was an OWI that was reduced. He's done everything. He's been compliant, right?
Yes, Your Honor. I tried to put his, I guess his detailed notes on the back of the ROA for you. Mr. Blisman's been perfect on probation. He has been very compliant. He meets with his case manager, Sadie, and he's up to date on everything. I think the only thing we're trying to encourage him now is actually to get his interlock installed so we can get his restricted license. But very compliant with all of his terms and conditions, Judge.
Lisa, give me another review hearing date in 4 months, sometime like the latter part of this January, please. We'll reschedule this. You're doing great. Happy how you're doing, proud of you. And I'm glad that this is all working out right now.
You already have them set up for 4 review dates.
Okay, when is the next one?
January 2nd at 8:30.
January 2nd of 26 at 8:30 in the morning. So we'll give you another notice if you want one. Keep doing what you're doing. You're doing great, okay? Thank you.
Judge.
All right, recalling S&D Investors versus Ladero Garner,
Yes,
501355. Mr. Garner, your name again?
Ladero Garner.
Mr. Goldman?
Present, Your Honor, 64231 for plaintiff.
I have this, sir. This is not sufficient. This one, you cannot, look, I want to give you the benefit of the doubt here, but you cannot fail to comply with court rules when you're responding to documents, or in this case, an amended complaint or a complaint. You can't just, you have to go through each averment. So I'm gonna go ahead and I set a pretrial, I think, for today. Did I not, Mr. Goldman? Give me a.
Your Honor.
So,
But Your Honor, also in the last order, Your Honor, indicated that if an answer wasn't, a sufficient answer wasn't filed, there would be a default. We would ask for default, Your Honor. This is the second time we've had to do this.
Oh, you denied this, you denied.
I know.
hang on a second.
Your Honor, in the answer that he filed, if you look, for instance, at
I
the
want to
second,
look, for the other order. One of the, I'm telling you, e-filing and I are not friends, Mr. Goldman.
Your Honor, the other order only said he had to file an amended answer or default would enter.
Right. That's not
But you had indicated.
All right, here's what I'm doing. I'm not gonna grant that now. You're gonna have to file a motion. It is clearly deficient. You can file a motion. We'll give you a motion date right now. Plaintiff attorney to file a motion to strike answer. I'll just make a note. Plaintiff attorney will file a motion to strike amended answer. And we will schedule that in 3 weeks out. That'll give you enough time, correct?
Correct.
All right, give me a date.
How about- How about October 6th at 8:30?
Is that good?
Yes, Your Honor, by Zoom, if you would permit.
Yeah, October 6th at 8:30, that will be the hearing date, okay?
I'll file a motion and a notice of hearing, serve it correctly.
You gotta comply with rules, Mr. Garner. I
Yes,
mean, I don't know what to tell you. Okay, I'm not gonna do the pretrial. We'll schedule it over for motion hearing that day and also for a pretrial on that day,
I know.
October 6th at 8:30.
Thank you, Your Honor.
Thank you. Have a good day, sir.
Bye.
Do I have anything else on there?
Leave out.
Just gonna ask if you have a phone in here, make sure it's silenced, please. I do not appear to have phones going off, so if you have a phone, make sure it's silenced, please. All right. Vicky Lynn Chung. 25T646252. Could I have Selena Woodward and Griffin Menser seated at the table here? My right, your left, please. Ma'am, your name? Good morning. You're going to plead responsible to impeding traffic, correct?
Yes.
For that charge, responsible or not responsible? Plea is accepted. Speed's dismissed. 60. Cash your in at all to your right. Have a good day. Selena Lai Woodward. 25T646253. Your name? Good morning to you. You're going to plead to impeding traffic. True? The speed will be dismissed. To the charge impeding responsible or not responsible? All right, I'll accept the plea. Dismiss the speed. 150 is your total. Go down the hall and take care of that. Good luck. People against Griffin Thomas Menser. 25 F244558. Your name?
Griffin Menser, sir.
All right, so you're going to plead to impeding traffic.
Yes.
Okay. Good enough. You gotta slow down a little bit, okay? 47 and a 25. You can't be driving like that, all right? So slow down, please. To the charge impeding traffic, responsible or not responsible?
Responsible.
Okay, I'm gonna accept the plea, 150, cash you into the hall to your right. Have a good day. The original charge dismissed. Michael Ross, 25F244552. And could I have Gary Oswald seated at the table there? My right, your left, please. Your name, sir?
Mike Love.
All right, so you're going to plead to impeding traffic, true?
Yes, Your Honor.
Responsible or not responsible to that?
Responsible, Your Honor.
All right, I'm going to accept the plea, 150, cash your end of the hall to your right. You're all set. Have a good day.
May I plead the court? May I have a little time?
How much time do you need?
Till this Friday.
Okay, no problem. I'll just make it next Monday. You can go right online and pay that with your case number. So that'll save you a trip here. $150 by the 22nd, a week from today. Okay?
Thank you, Your Honor.
Have a good day. Gary Wayne Oswald, 25B149319. Sir, your name?
Gary Wayne Oswald?
All right, you're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that? Please accepted, 150, cash your end of the hall to your right.
Thank you.
All set. People against, William Abraham, 25B149260. And could I have Destiny Amato seated at the table here?
Avoid this court. He got picked up on a different issue that I believe happened prior to this indictment. So as a result, we had a discussion in chambers about the electronic monitor. He was doing fine on that. It got cut off by the sheriff's department up in their county, up in the city of Warren, up north in Trumbull County. At the time that happened, Mr. Rogers was engaged in trade school just over the border in Pennsylvania. It was close to the border up there. So he was taking the trade school. He was gainfully employed. He was doing the right things, trying to. When he found out also the mother of his child that's in Virginia passed away. So that's created additional issues for him to have to deal with, which is very difficult to do while he's down here. He is not the main defendant in this case, Your Honor. He's one of like 4 or 5 people that have been charged. The primary suspect in this case pled out about a couple weeks ago or a week ago. The evidence so far to me is not very strong, but I would still respectfully request that he have a bond, go back on the bond that he was on, along with the electronic monitor. He's got, according to him, he does have a child that has special needs. Maybe he can say a word or two about that.
Yes, sir.
Go ahead.
Morning, Your Honor. Yes, I would like to just be able to transition back into the community so I could be able to be there for my special needs child and also my other child that I'm currently in court. I am currently in court to get custody of, Your Honor.
Your Honor, also, I think there was a matter up in Warren County in municipal court he was trying to take care of when he was brought down here. So I'd like to see him get back out. I realize the position of the probation, but by the same token, we're not set for trial for a while. I'd like to at least give him a chance back on the electronic monitor. And, if he messes up, he messes up. But this particular incident was not a result of something that he was evading. It was cut off, like I said, from the Trumbull County Sheriff's Department.
Mr. Fuse, do you have a position in any of this?
Your Honor, nothing additional from the last time we were here. I did get notification from Officer Wilson confirming that they did receive the GPS unit back at the last hearing, but nothing beyond that, Judge.
So here's the thing, Mr. Rogers. I don't really have a lot of confidence that you're going to obey the terms of the release if I put you back on monitor. I have a lot of questions about whether or not you're going to be able to do the things that you do. Like I said, I don't have a lot of faith in that. But I got to tell you, I have some faith in these ladies that are here with you. If they're going to make the trip all the way down here twice and they're going to turn back in my equipment, I'm willing to give you the benefit of the doubt and we're going to try this again. So I'm going to release you on your own recognizance. I'm going to order that you be supervised on electronic monitored supervision with a curfew. So you and probably Officer Wilson again will work out a curfew. Make sure that you are abiding by the terms of your release. If you get into any trouble up where you're from, you need to make sure that you get out in front of it with Officer Wilson so that this nonsense doesn't happen anymore. Okay?
Thank you, Your Honor.
All right. I'll see you at the conference.
Thank you.
Your Honor, given the, I know our trial date was set in anticipation of a to-be tried date because he was in custody. Do we want to leave the conference and trial dates on, or?
I'd prefer to do that.
We might as well leave them where they are.
Okay.
I mean, it's November, right?
Right.
Yes, November 17th. is
Yep.
trial.
We need to get this case over with by then anyway.
Okay.
All right. That's all.
Thank you, Your Honor.
You can have a seat there if you want, sir.
How's that?
Your name?
Wayne Bader.
All right, so you're going to plead to impeding traffic. They're going to dismiss the avoid traffic control device. True?
Yes.
To that charge of impeding traffic, responsible or not responsible? All right, please accepted 165. Cashier into the hall to your right. Thank you. Destiny Raquel Amato, 25B149134. Your name, ma'am? All right, so you're going to plead to expired plate. True? To that charge, responsible or not responsible? All right, I'll accept the plea. What happened?
I just wanted to see if I can get like a.
Yeah, how long was it? It would expired in April. Why didn't you have it renewed?
Yeah, for some reason it's still under my mom's birthday and it's my birthday's in November. So I wasn't thinking it was expired and I thought I renewed it back in November.
All right, I'll tell you what, I'll make it $80, okay? Have a good day. Cashier into the hall to your right. Good morning. Good morning. Hannah Breland Buchanan. Breland, maybe. Hannah Breland Buchanan, 25T646099. Was I right the first time? Wrong the second time. Okay. How are you? Your name? You're going to plead to impeding traffic. They're going to dismiss the speeding, right? That charge of impeding, responsible or not responsible? Please accepted. 150. Yes, you're into the hall to your right. You're all set. Good luck.
There's a couple on Zoom that are ready.
Okay. Sir, I'm going to have to ask you to take your hat off, please. Your hat.
Alyssa Jones and Faraz Sharp can go up.
Okay.
Do you have Jones and Sharp?
Alyssa Christine Jones, 25B148251. Mr. Holmberg, are you on this?
I am, Your Honor. Ms. Jones, yes, I can go get the defendant. She's outside. I can grab
Did you
her.
file an appearance?
Yes.
Do we, and we have one, Lisa?
In the file.
She was supposed to be here on August 28th for a probation violation.
Correct. And she showed up, we showed up late. She showed up, I believe that, I think that was the day before Labor Day. Don't quote me on that. Or that was the Thursday before Labor Day. She showed up. It was late, to be honest, with the court. We then got this.
All right, go get your client. We'll handle this.
Yes,
We'll take it. Sir, you have to take your hat off, dude.
Close the door. She's here, Your Honor.
Name, ma'am?
Say, you say your name.
Alyssa Jones?
Need to see her.
Oh, sorry.
Okay, so I just want to be clear. She never showed up for this violation hearing that was generated August 7th that alleges she had a 0.31 on a PBT administered by Flat Rock. And it apparently they were called to the defendant's home for an alleged assault. So we're going to handle that. And then I'll handle her motion.
That's fine.
So how was she going to proceed on this case with this motion, with this?
She would plead guilty with an explanation.
He actually has 2 counts, and I'm going to need Ms. Wilds in here. Count 1 is she failed to refrain from consuming alcohol, as I just outlined. Count 2, she failed to submit to twice monthly chemical testing as ordered on August the 13th of 15. So she's going to plead to 2 counts, correct?
That's correct. I wasn't aware of the missed testing, but she did test positive for alcohol that evening. That's the only.
Missed testing. I went to test.
Oh, so she's.
Did you miss testing?
On the 12th I did, or the 13th maybe, but I was there within 24 hours.
Okay, but you did miss on the 13th. So yes, you would plead guilty with an explanation, Your Honor. I apologize.
And if you plead guilty to these 2, these would be 2 technical violations. You could get 10 days. Do you understand that?
Yes.
You are entitled to a hearing. You have the right to a hearing. You have the right to bring in your own witnesses at that hearing. You have the right to cross-examine the probation department's witnesses. You have the right to testify or remain silent. And if you choose to remain silent, that silence would not be held against you. They have the burden of proof. They have to prove you violated by a preponderance of the evidence. If you plead guilty, you're waiving all those rights and we will not have a hearing. Do you understand that?
Yes.
Okay, just try to keep your voice up a little bit better for me, okay? You understand everything I've said?
Yes.
As to count 1 that you failed to refrain from consuming alcohol or drugs testing positive on a PBT on August 2nd of 25 with the results of a 0.31% BAC. How do you plead?
Guilty.
Did you consume alcohol on that date?
Yes.
How much did you consume, ma'am?
Well, we went 3-1. You consumed quite a bit, correct?
Yeah.
Yes.
Well, you gotta talk to me, please. Talk to me. How much did you drink?
I would say a few drinks over the course of the day.
What a few means. That could mean 3. It could mean 32. I don't know what you mean. Roughly, how many drinks? What kind of drinks were you consuming?
How much did you have? Did you have mixed drinks or did you have beer or a different type of drink?
It was seltzers.
Alcoholic seltzers?
Yeah.
They had vodka in them?
Yeah.
Okay. And
money, ma'am.
How many did you consume?
I'd say like 6.
6.
How big were the seltzers? Were they 32 ounces? Ms. Jones, you are being asked a question by a judge right now, and you are in a courtroom. I don't care if you're in a lawyer's office or not. You are in a courtroom. I want a straight answer from you. I want to know how much you drank.
They were 12 ounces. I would say 6 over
Well, with a 3-1,
the 3-hour period.
You drink more than 6 over. So when did you start drinking? We'll start there.
All right, that's okay. She just doesn't want to answer. I get it. Ms. Jones, I want to remind you, you're in a courtroom.
Oh, to over. I don't.
Ms. Jones, if you want to carry on a conversation with your lawyer, you tell me and we'll come back to you. But otherwise, you look at me and you talk to me and you answer me truthfully and completely. Do we understand one another? Do we understand one another?
Yes.
Can I have a minute, Your Honor? I'm sorry. I apologize. Give me one moment, please.
Is staff coming in? Yes.
Your Honor, may I have a moment, please? I apologize. Can we come back? Can you recall our case? Is that okay?
You'll go off the record on this and I'll come back to you. Tell her to change her attitude. People against Faraz Cartel Sharp, 24G700688. Faraz Sharp here?
And Zoom.
Oh, okay. Mr. Sharp, you got to start your video and unmute.
Hello.
Your name?
Ross Sharp.
Okay, so he entered a not guilty plea, and the idea was going to give him a lawyer today. I wrote that down. Did you talk to a lawyer? Yes, Mr. Sharp?
No, I did not.
Okay, we're going to give this one to, who would handle this, Lisa? Mr. Nahikian?
Mr. Nahikian, I'll put him in a breakout room.
Okay, and tell Mr. Nahikian that we have the file. Vince just walked out.
Okay.
All right, people against Iris Ayala, 25F244595. Could I also have Trevor Dobruck seated at the table and Rafael Santos seated at the table, my right, your left? Your name, ma'am? Good morning. You are going to plead responsible to impeding traffic, correct? And that's what you want to do?
Yes.
All right, to that charge, responsible or not responsible? All right, I'm going to accept the plea. 160 is your total. Speed's dismissed. Cash you into the hall to your right. Have a good day. Trevor John Dobruck, 25F244555. Good morning, sir. Your name?
Good morning, Trevor Dobruck.
You're going to plead to impeding traffic as well, right?
Right.
Good record. To the charge, impeding, responsible or not responsible?
Responsible.
I'll accept the plea. 150. Just slow down a little bit, okay?
Any.
Cash you into the hall to your right. This one's it, Mr. Nahikian. Thank you.
Thank you.
Rafael Santos Jr., 25B149325. Your name?
Rafael Santos Jr.
All right. So you are going to plead to impeding, right?
Yes.
Got to be careful. If you get another one of these and you see my name on it, you're not getting impeding, okay? To the charge of impeding, responsible or not responsible? 175, original charge dismissed, cash you into the hall. Good luck. Carol Ann Butler, 25B149112. Mr. Holmberg needed to go into a breakout room with his client or at least talk to her off the record. So it might be a couple minutes, but I don't think it'll be. No, just stay there. I don't think he'll be that long. Ma'am, your name? How you doing? Pardon? All right, you're going to plead to impeding?
Yes.
Responsible or not responsible? I hope you're being real careful though, ma'am. Okay? 195, cash your into the hall to your right. You're all set. Thank you. Brian Dwayne Mabe, 25F244548. Your name, sir?
Brian May.
Good morning. You're going to plead to impeding, right? Responsible or not responsible to that? Plea is accepted. 150. Cash your into the hall to your right. Have a good day. People against Sherry Nicole Bowman, 25W839397. Good morning. Your name?
All
right. You're going to plead to impeding, right?
Impeding?
Oh, wait a minute. What do you say?
Then no proof of insurance.
Oh, I'm sorry. Oh, you just want an informal hearing.
Yes,
Slow down. You want an informal hearing, it says here. You charged with no proof of insurance.
Yes, the vehicle's not my name, Your Honor.
You can't drive a vehicle without insurance. I don't care whose name it's in.
I was unaware that it wasn't insured at the time.
It's your responsibility to know. I don't have a problem if you still want a hearing, but if you didn't have insurance, whether you knew or didn't know, you're gonna lose.
Understood.
You still want to have a hearing?
Yes, I want to come back and prove insurance.
Okay. We'll set an informal hearing, okay? Lisa, what do you have?
September 25th at 9:30.
September the 25th at 9:30 in the morning, okay?
That'd be great.
All right, you can go down the hall. We'll give you a notice, all right?
Thank you.
Best of luck. Thanks. Mr. Holmberg, are you ready yet? If you're not, that's fine.
There you go.
Cedric Feinman.
Mr. Burbank informed me that it's going to be believed today.
Is Mr. Burbank around by any chance?
Ron,
Am I in the wrong place? Am I in the wrong room?
I think Burbank might be. We'll find him.
Yeah, it's not long.
Ricky Sloan.
Ready now. Classic. That's right. So smart, Judge. I had a Ricky Turner. I apologize. Yeah, that changed about this plan different than last week. I'll be leaving on
So where was going on? Where we headed on?
Actually, pretty close to getting to the death. I'm trying to.
Yes, sir.
We got it. I can't think of that. Yeah, you can give me 3 weeks.
Okay, I'm just going to set 3 weeks. Okay.
Thank you.
We set 3 weeks on Sloan's 2 cases at the agreement and request of the parties. Thank you. Wyatt Willoughby. Right.
Vice President Judge Simpson. May I ask the court to move this to another setting, please?
Let's see. She's kind of busy. Sounds like I think you are. Well, we're headed on us. You just have. Is that the one that's
It's gonna play, Judge.
and Ronald LeBeau? John.
Ready. Ready.
Okay, let me see the parties on this one. Thanks. Just real quick, thanks. So sound. You didn't get it going off your food? Not mine. Here's what we're going to do. Y'all ready? The truth. Something else we get tried. But who's going to do all these things? You didn't get anything done. You're sure talking. That's what we
All right. This is one of Sonny's cases, but I've got a ready judge. You think so? Well, there.
Okay, Glenn Duncan, Langston. On Jimmy, and what did Langston have to say on Mr. Duncan?
We can go back and forth, but I don't know what his final decision is.
Have a seat. Yeah, we don't want you up here without your lawyer. I don't know where he is.
Might be in the back, sorry.
He's in the back. But you're Glenn Duncan. You're here. Y'all don't know?
I don't know what his final decision is.
Marvin Parker.
Ready. I'm not ready. Ready on that as well, Judge.
And Tommy Williams.
I'll take it. Whichever one you choose.
Ken Bailey. Langston.
It's supposed to be Jim, but that was a typo.
It's supposed to be who?
Jim Bailey.
Oh.
Typo.
No, but that's Langston.
There's some, well, Langston gets you, there's some motions to quash some subpoenas on those that we need to talk about.
Ricky Turner.
This one.
Ricky Turner.
Needs to be
That's
fixed.
ready. John.
Ready, yeah, ready. Thanks.
All right. All right, on Everfield, the lawyers, come on up, please, if you'd be so kind. That's Tom Kelly. Tom, where you go? You went. On Tovar, Mr. Wilkerson, Ian and Sarah. Come on up, please.
You sign people look good.
Thank you.
We have Tom, Your Honor, if you wanna,
Yeah, the one.
big Tom, if you wanna talk about that.
Which one are we trying to get at? Which one did you need to try?
Oh, Tovar.
So that's going to be done.
Okay.
On time, so.
That's gonna be a plea on Everfield, I believe.
Okay, David Tovar's one.
Ready.
Stand by. Two is, Sarah, if that happened to fall through, is Stephen Matlock ready?
I could do Stephen Matlock if I needed to, Your Honor. Yeah.
Okay, two.
So he said $1.
I didn't even put it on top of it.
And Marvin Parker. Yep.
Okay.
Ronald LeBeau. On Ronald LeBeau, John?
Yes, sir.
And Mr. Ham? On Ronald LeBeau, I'm gonna send that to Judge Wortham.
You can't do that for two reasons, Judge.
Oh, that's a jail.
Yes, Ricky.
Ricky Turner? is Ricky Turner. That's who I'm going to send. Daniel?
Been in communication with Judge Rankin in regards to a different case to try to get moved over there. They do not have a jury panel anymore. Something came up with him.
She just told me to send the other.
I have an email they canceled it, Judge.
Hey, wouldn't we get this thing from Judge Wortham that they could handle the case? They said, no, they don't have it. They don't have a jury.
That's the last thing I heard on Friday.
Oh, I wasn't here on Friday.
You didn't hear that from them this morning? About they're ready to handle?
If they let us know Friday, I wasn't here, and then I was prepping everything this morning at the.
My understanding is something came up for Judge Wortham.
My apologies, Judge. I didn't.
That's okay.
You discussed in Washington. You discussed it. You said he did.
Okay, so we have Tobor, Matlock, and Jimmy, did you say y'all could do LeBeau?
Yes, sir. I also have Dixon ahead of that, Judge, if you want to consider that. You want to know? Put it on the tablet, everybody knows.
I didn't see Burbank though. I don't know what the word is on him.
Yes, sir. I just want the court aware about that.
Okay.
Nothing from Mr. Burbank.
Tobor, Matlock, LeBeau, Dixon. Reset on Christian.
So we got another 28 minutes.
It's whatever date that we were all here and they're voting at the top. And it was saying, don't we say it's 1250?
Hey, do we have any other? Do we have any other civil district judges? Do we have any other civil district judges who?
Today, Judge.
Are in trial?
For them. Everybody else in trials.
Everybody else is in fun. All right, and that's the lineup for us. Others are pleas or resettings. Okay. Who's ready on the queue for pleas? Do we have anything? Yes, no?
Yes, we're working on stuff.
Our clients that are online that do not get paid every go.
Yeah. On, and LeBeau, that's a trial. That's going to be a trial. I'm not accepting an agreement on any sort on that one. That's going to get tried. Also, hey, John. Ricky Turner as well. No deal on Turner. Does he have a resetting?
We're resetting now on 5.
I'll John, but I just.
Okay.
Sorry, people.
Langston, what do you have?
I got the plea off the trial docket. That's going to be Mr.
Is it ready?
It's ready.
Who is it?
Caleb Watson.
Christopher Watson.
No, I'm sorry. Or Christopher Watson. I said Caleb by mistake. Christopher Watson. He's ready to be ready. And he's on the trial docket.
Okay. Here, all these other fellows. Is it in the back?
He's back.
We need Christopher Watson, please. Thank you.
So you might have to give you a tablet. Yours is updating, so.
Do we have the new tablets now? We'll never get that. That's my bet. That's the line on Las Vegas. We'll never go.
Very pessimistic. Yeah.
It's realistic, not pessimistic. It's realistic. Yeah. Does he need to?
Yes.
You need to fingerprint. Thank you.
Please raise your right hand with the right arm. Have you got the stuff you got? Okay, you got your right fingerprint. Hold it. Look on your flat. Just a minute. Thank you. Get it one more time. I need you to. That'll be same one. The same as the right one. It has to be flat. You roll it. Okay. Because I've got to steal.
No, it's really.
Okay.
23 CR 1254 is called State of Texas versus Christopher Caleb Watson. That's you, sir? Yes, speak out so she can take everything down. That's you, Christopher Watson. You're here with your attorney and the state's attorney. Mr. Adams, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 25th, 2023 in Jefferson County, Texas, you committed the state jail felony of burglary of the building. Do you understand fully what the indictment states?
Yes, sir.
If convicted of such a crime, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 18 months in the state jail, and will be given credit for all time served in accordance with that particular case. Do you understand?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
That's incredible.
Okay. You know, that is good.
It's not right. It's not right. Did I hear?
It's not.
So even read this on this. I'm not kidding. It's doing something weird. Look at this right here. There you go. Y'all saw me. I tried to write it down and it wouldn't write. And then
Third time's a charm.
when are we getting the new pants again?
October.
This year?
October 1st. Well, they're going to order them October 1st.
Okay, if I follow this, it's incredible. Like I'm in the Indy 500 and I've got a Volkswagen Beetle in the race. If I follow this agreement, you have no right of appeal. Do you understand? So, again, how do you plead to this indictment, guilty or not guilty? You're pleading guilty today voluntarily and because you are guilty? Question?
Yes, sir.
I show you what's marked as State's Exhibit 1.
I got it.
Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney or the contents all true and correct.
Yes, sir.
State's Exhibit 1 tendered into evidence.
No,
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with from indictments from World 2. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1. You made it part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I will follow this agreement, sir, and I will make the findings that you are, Mr. Watson, pleading guilty voluntarily, knowingly, intelligently. You were mentally competent to be able to do that. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 here admitted to find you guilty beyond a reasonable doubt, and I so find you guilty beyond a reasonable doubt of the state jail felony. I am following this agreement. You were hereby sentenced to confinement in a state jail for 18 months, and you will be given all credit for time served in accordance with this case. Do you understand what has happened to this? Anything else on this? That is all. Thank you.
Thank you.
Yes, sir. Please. Hey. I don't see you should search it. You say where? Here, well. I'm not kidding.
Yours is almost done updating, Judge, and I can give you. So it's good to go.
Who's up next? Please, anybody? At all? What's your
Bill this way.
We'll go, Jim.
Dariante, Everfield?
I know that. We're moving your room.
There's two cases. One's going to be dismissed.
We're pleading to both, Jim.
Yes. Yeah.
I mean, both.
But unless it's not, we should leave here. If you give me that tablet, Judge.
No, I need.
You what?
I need.
Oh, we need the file.
Yeah. Everfield.
So, one set of plea papers when I handed you that tablet.
Yeah.
Like, if you'll
I
hand
just
it
got the murder. No.
log in and see if the other set's there.
And Your Honor, we'd also request that tomorrow morning we be allowed to, the family members be allowed to do an allocution on this case. Just give them time to get here from tomorrow morning before everything starts. We can just get it.
So raise your right hand, you swear or affirm to the people with you and give up yourself to God. Think of your next one, friend. Ready for the flat right there. One more time. It's a black right there. We'll just need to adjust.
22-39802 is now called the State of Texas versus Dariante Kelvin Everfield. That is you, sir?
Yes, sir.
Present with Mr. Kelly, your attorney, and the state's attorney.
Yes.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
We waive full reading, Judge.
In summary, this indictment alleges that on or about April 14th, 2022, in Jefferson County, Texas, you committed the first degree felony
This is yours. It's
of murder by shooting the complainant, the victim, with a deadly weapon, namely a firearm. Do you understand what you were charged with?
Sir.
If convicted of a first degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable?
Yes, sir.
An agreement has been reached in your case. If you would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
mine.
Yes, sir.
Okay.
So moving slowly today. How do you plead to the allegation of murder in this indictment, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, Mr. Kelly. Is everything true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence. And it's without objection, it's admitted. Among other things, sir, the states you are mentally competent to enter your guilty plea. This is being made freely and voluntarily. You know what you've been charged with. The indictment's read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. States Exhibit 1, it's made a part of the record for all purposes. Is a pre-sentence report ready here?
Yes, please.
I will follow this agreement. Anything else to add on that?
Not on that case. Just Your Honor, we're requesting the allocution be allowed for tomorrow morning.
Yeah. But anything else to add on this?
No, Your Honor. No.
Okay, if nothing further, I will make the findings that Mr. Everfield, you are indeed mentally competent to enter your guilty plea. It's being made freely and voluntarily. You know what you've been charged with here. It went black. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and the lesser inclusion of it. Just you were giving up your rights to a jury trial on the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all who so help you God. State's Exhibit 1 is made a part of the record for all purposes. Anything else to add?
Not on that case.
All right, I'm going. Do you understand what has happened today, sir? Okay. The only other additional finding the court is going to make is that the judgment shall reflect affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense, and that will be reflected in the judgment. Do you understand? Anything else? Now we have another case.
Yes, sir.
And this is cause number 23CR1270. And
Here's this one if you want to just hold it out and then.
we had to start over from the beginning. On it. So good. Machinery's not working right. It's a good sign. It's good luck in Haiti, but not here.
Haiti.
And this is cause number 23CR1270. Does the defendant waive a formal reading of the indictment and the arraignment in this case?
Yes,
Can we proceed in summary?
Thank you.
In this particular case, sir, the indictment alleges that on or about April 14th, 2022 in Jefferson County, Texas, you committed a third-degree felony of tampering or fabricating with physical evidence with intent to impair it in a murder investigation. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in this case. You would be pleading guilty, sentenced to 10 years in prison. This one's concurrently.
Yes, Judge.
We'll run concurrently with the murder case that you were just sentenced to in cause number 22-39802. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes,
So you're pleading guilty voluntarily, and because you are guilty,
yes, sir.
I show you what's marked as State's Exhibit 1 as well in this case. Did you sign that? Understand it? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection. It's admitted. Among other things, again, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation of your attorney on this case. All true as states, so help you God. State's Exhibit 1 was made a part of the record for all purpose, pre-sentence report waived. If nothing further, I'm going to follow this agreement and find Mr. Everfield in this third-degree felony of tampering or fabricating with physical evidence. I am going to find you are mentally competent to do this. You will have an understanding of what you're charged with. You understand fully the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I so find you guilty of this third-degree felony. I am following this agreement. You will hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years, and this sentence shall run concurrently with the sentence in the murder case previously assessed today in cause number 22-39802. Do you understand what has happened, sir?
Yes, sir.
Anything else?
Nothing.
That is all. Thank you.
Thank you.
Good. That's it off the trial docket, correct? Yes.
Yes.
So far, Judge, Mr. Burbank did let me know that Cedric Fontenot was going to be a plea.
Wait, I'm Mr. Burbank.
Okay, Langston,
I'm ready.
Andrew Diaz,
That's a plea. I sent it to you already.
where's he? In the
He's in the
back.
back.
Andrew Diaz, please. Andrew Diaz.
I sent it.
You got it. I got it. We all have it.
We good. We good.
Oh. Do you need to fingerprint?
Yes, sir. He's gonna have a fingerprint. Oh.
Thank you.
Mr. Diaz, please raise your right hand to the forefront and have the truth and evidence to be God. Just you can do that. I'm correct. There. You can have one more time. Same one. Place right here.
We now call cause number 25, CR 642, the state of Texas versus Andrew Diaz. That's you.
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. And does the defendant waive a formal reading of the indictment and arraignment? In this case, can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about April 19th of this year, 2025, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. You understand what you are charged with here?
Yes, sir.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached where you will be pleading guilty and placed on deferred or unadjudicated probation for up to 10 years. And is there any restitution? No. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan in this case?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Guilty.
So you're pleading guilty voluntarily. And because you are guilty.
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with? The indictment's been read to you, or you've read it. You understand it fully. You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer here. All true.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. In this case, pre-sentence report is waived.
Yes, sir.
I will follow this agreement and find, Mr. Diaz, you are pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, Your Honor.
There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt in this case. However, the court is going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. If you do well, it can be shortened to 1/3 of it. There will be terms and conditions of probation, including anger management, which helps you make decisions under crucial decision-making situations. And that will help you. Also, the court, even though you have not been found guilty, so long as you follow these terms and conditions of probation, the court finds there is sufficient evidence to support an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. It will not have any practical application unless you fail. Then your probation can be revoked. You can be then found guilty, sentenced up to 20 years in prison, and that prison sentence would have to be served at least 50% because of the affirmative finding of a deadly weapon. So a lot riding on you doing well. So are you going to do well?
Yes, sir.
Okay, it's up to you. Anything else? That is all. Please just talk to the probation officer and
there's an issue we need to deal with off the trial docket on Jim Bailey. There's some subpoenas that were, some motion to quash were filed that I think we need to deal with an issue that's come up many times if we could, Fleischer. So we got Mr. Stelly here's filed the, I think the objections to him. Where that's going to.
There's also, wasn't there another one?
Yeah.
Howard Price?
Howard Price, yeah. Yeah, deal with them both.
Okay.
Oh, did you get my response? I emailed it.
Wait.
You won't,
That's a question. I don't know.
I emailed everybody. This is the part of the email.
Here's, that was attached to files.
You want to take a time and look at my response before we, because I have some other matters.
This is just an issue that's come up. I think we need to deal with it so we can figure out what to do from here on out.
Okay, it's not set in the queue for trial today, correct?
No. Well, no,
it's on the trial docket, but it's.
No, I didn't name it on trial,
No,
though, right?
No,
I named others.
No, so that's why, but this is going to come up again and again. So we kind of need to have an answer.
Okay, we're going to stop everything we're doing and work on this then, right? That's what everybody wants.
Yes, sir.
Well, look at it. Did you see my response? Yeah, I want to read my response before we imagine that. Yeah, so we can do the other stuff.
This is data, right?
Because you had a chance to read my response.
Yeah, I hadn't read it.
Right. Judge, I got another.
But I can't. I'm a speed reader. Oh. We have two cases I'm looking at?
Yes, sir.
Yes,
the same issue.
Price?
Yes, sir.
Yes, sir. And what I basically did, was prepare and submitted my response in a similar case next door. And I provided that to Mr. Stillwell. He already has it in the court as well, because the issues are exactly the same. And it says defendant's response in opposition to motion to quash subpoenas.
Okay, these are
These are subpoenas to law enforcement agencies asking them for things that we're required to give them in discovery.
But that's why I wanted you to read the response, because in my response, I cited several statutes and cases.
it looks like they're word for word the same, right?
Right.
Okay.
One paragraph different, Your Honor, but yes, for the most part the same.
Okay, tell me, before these objections were filed, what was the status of the case and what precipitated it?
Well, both of them were set on trial, that's right.
Yeah. I know that.
The underlying.
You filed, you sent.
Motion. I filed.
Stand by. Let's go in time. Cases are filed, they're indicted, then we're getting ready for trial, right?
So,
and then you file subpoenas. You send out subpoenas for witnesses, correct?
Correct. Documents.
For documents to the chief of police.
Correct.
Port Arthur. Okay. Then that triggers a response.
Correct.
That Mr. Stelly is representing, I guess, the city of Port Arthur.
Yes, sir.
On.
Correct.
And what was the reason for your subpoena for the chief of police?
Well, it's for the documents, not for him to testify personally. In particular,
what documents are you attempting to get before the fact finder?
One is any and all police reports relating to Linda Jones, who was the complaining not the complaining witness, but the mother of the complaining witness in this case, and any and all police reports related to my client, Howard Glenn Price. Now, the state's position is that you have to get that information solely by request under 3914 through the district attorney's office. What I cited in my brief, Judge, and I actually look at it and I highlighted the key points is there's nothing in the law that states that, nothing, zero. Matter of fact, if you read 3914, the language of 3914 is specifically the state shall produce. It does not say district attorney. And courts, and I've cited the cases, have defined state as law enforcement, district attorney's office, big umbrella. That is the state. And also, I would like to bring to the court's attention that 3914 is not something that's mandatory by the to be invoked by the defense. So if I don't invoke 3914 at all, if I never send a letter requesting discovery at all, I am still allowed to subpoena documents from law enforcement. There's nothing if 3914 is triggered by the defense making a request. And specifically, Judge, what I did was I highlighted for you, just so you don't have to read everything. If you just look at what I highlighted.
What's this? Oh,
well, yeah, that's the response. And that's the response in another case, but the issues is the same. So I just included in this and I sent that email to you. So the long and the short of it is that when you look at their objection, in their objection, I don't see any case. And specifically when they refer to 3914 itself does not say that discovery in criminal proceedings shall go through the district attorney's office. There's nothing in 3914. I asked them to bring out 3914. I have 3914. They can't read that to you. It doesn't exist in the statute. The statute does not say that at all. Also, specifically, 3914 does not. There is nothing in 3914 that precludes you from sending a subpoena to law enforcement for records. And these particular records are relevant in my particular case. Also, there's been many times where, for example, the state will, when the PD puts together a case, it's not necessarily the PD is even giving the state everything that's in their files. So particularly my position is the argument that they're making is not supported by the statute that they say, and you can plainly read the statute itself. It says state, and it's not even triggered unless the defense even sends a letter. So at the end of the day, Judge, my position is very simple. What they're requesting is not supported by case law, because if you look at their motion, they cite no case law, none, zero. And then the statute that they cite, it does not say what they propose. So they can't win on a statute that doesn't even support their position. So I would ask that the subpoena objections that they made be denied, and that we prevail on the principle of that what they cite is not even in the law. And I got the law itself to read. I included that in my response.
What are you trying to seek from the Port Arthur Police Department?
So, for example, in there, and Mr. Laird, I mean, he's representing the state.
What are you trying to?
I'll give you a specific. So
just don't tell me.
No,
the Constitution was written. Just tell me what did it say.
So specifically, like in the Howard Glenn Price, Linda Jones is the mother of the child, right? So I requested any and all documents, police reports that is not in this. This is something that's not in the discovery portal. So relating specifically to her, because I'm entitled to impeach their witnesses. And she is going to be the main witness besides the child. As it relates to my client, they can offer anything they want to offer as far as punishment of my client. They can offer any relevant conduct as far as punishment when he takes the stand. That is not in their discovery portal at all. And I asked that specifically, any and all reports, investigative reports, call service relating to Howard Price. That's my client. I'm entitled to that for my client. And any other information about this particular case that they haven't produced. My point to you, Judge, is, and like I said, I've read 3914 several times.
You said that several times.
Right, and you're right, I apologize. It does not, the statute does not say what it's not in there. You can read it, it's not in there. So again, with that being the case, the long and short of it, if they subpoena my client's medical records, they don't come to Langston and say, well, hey, can I get your client's medical records through you? If they subpoena his school records, my client's school records, they don't say, well, hey, they go directly and get them. I can do the same. And matter of fact, since they mentioned 3914, I'll give you the best case example, Judge.
Where does this end?
Well, here's what it ends right here.
Just get the
here's what it ends right now. Here's what it ends right now.
Okay.
Prior to indictment, my client would be entitled to an examining trial prior to indictment. All right. It's my understanding, Mr. Laird can tell me, the district attorney's office does not give you discovery prior to indictment. If I have an examining trial, I can subpoena whatever records I want to from the police department. So
no.
At the examining trial.
No, you can't.
I'm sorry.
There's always built in a relevance.
Well, yes, you're right.
A relevance.
You're correct.
It's the spirit of all law. You just don't ask for, we want every piece of paper on the planet, and we'll wait as long as it takes. It has to be relevant and reliable.
Correct.
Relevant and reliable. The two R's.
I misspoke.
But that's, I know what your point, what you're trying to get is as much information as you can.
Correct.
Which is what a vigorous defense attorney has an obligation to be that way.
And Judge, I think,
but what is the relevance of this matter that you're asking for? What is it relevant to a fact issue in this case?
Well, they're not going to put on their case without Linda Jones as being the mother. So Linda Jones, police reports, investigative data is relevant to the issue of, one, her credibility. Did she make any of these claims against my client in the past? Has she made false claims before in the past? Any issues regarding that would be relevant to this case. My client's own prior cases, which could be used in punishment, as well as to critique him, as well as any and all documents for this particular case that have not been produced, would be relevant to his defense, specifically of he did not sexually assault this child. And the judge, in terms of that, at the very least, and I think the court has done this in the past with CPS records, is that I would ask the court to look at the records that they have in camera and then give them to me. If you find records, look at them in camera.
There's a motion for that you file. You got to, if Judge, you just trying to surpass the discovery that's required by 3914 and also by all the rules of evidence that the state is required to give him. If he would request it from us, we could give him what he wants, but we've got to do a central location where he's not causing all these agencies to try to figure out whether they.
Yeah, I'm not going to open the door.
So,
no, they're willing to work with you. Yeah. Do it like we've done it for 18 and a half years, Skip, up here. We don't have a problem with it, but you just can't get a carte blanche request of data. It has to be relevant, reliable, and because data in criminal law, in criminal matters, is vast.
Yes, sir.
You've got to pinpoint it so that we're not chasing our tail and spending a lot of valuable time unwisely.
And I think,
and also here, also, you're wrong when you say I get to know everything about somebody. No. When you have requirements under the law that the state has to provide for discovery, which is mandated, and exculpatory information. Then when they put their witness on the stand, then you may end up opening a door of information based upon their testimony. But you can't open the door until it's unlocked.
And the same arguments that I made apply to both cases, Judge. It's not, we're trying to handle both at one time.
It's right now, I find it premature. And you're going to be required to give all exculpatory information and the information ahead of time under what 3914 is always. But y'all got to communicate before you get to me on this, and folks don't, because I'm going to be flexible. It's in the Constitution. The Bill of Rights have all the rights. I'm sensitive about it. I wrote a big article on it. I'm very proud of that.
Well, I hope you enjoy reading my brief.
Yeah, it's good. It's good. But I think it's premature. You may want to throw that out. You reassert it. It's in there. You can reassert it. But right now, let you work one step at a time and see. Yeah, I just don't want. Yeah. I don't want them to. Yeah, you're asking. So what you want is just information. You don't want to read War and Peace, every page of War and Peace. You want to get
not every page.
What's the subject matter that is relevant to you?
I realize. You take both those cases, huh? You doing both? Thank you, Your Honor. No, maybe
Yes, your excuse. Thank you.
Thank you.
So I'm going to hold these motions in abeyance and
Thank you, Judge.
take them up later when it's right. Now I've got
Judge, I got another plea off of the.
who is it?
That's going to be Mr. Jacquet. I sent that
Justin
as well.
Jacquet. Justin Jacquet, please. Here.
I sent that, Judge. You got it. And that's Mr. Jacquet.
In front of that lady, and she'll swear you in, sir. Thank you.
Jackass, please raise your right hand and swear or affirm to tell the truth and the truth and nothing but the truth, so help you God. Here. The right thumb print, right thumb. There you go. Right there. And get it one more time. I need the whole thumbprint. Okay, you go stand in front of the judge.
And even so, there's something.
Sure.
Hello. Mr. Adams?
I'll come back. I'll just check with my client.
Your client needs legal assistance here.
Appreciate you.
25 CR 772 is now called. The state of Texas versus Justin Jacquet. That's you. Present with Mr. Adams, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in a summary, Patrick?
Yes, sir.
In summary, Mr. Jackett, this indictment handed up in June of this year by the grand jury states that on or about April 25th, 2025, in Jefferson County, Texas, you committed the third-degree felony of theft of services. Do you understand what you are charged with? This, because the value of the service is $30,000 or more, but less than $150,000. This is a third-degree felony. If convicted, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you are facing here? An agreement has been reached where you would be sentenced to 10 years in prison. That would then be suspended. You would be placed on regular probation for up to 10 years. Most importantly, we need the money paid back, the loss, which is $1,257.97. Is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this third-degree felony of theft? Guilty or not guilty? I'm sorry.
He said guilty.
Are you pleading guilty voluntarily and because you are guilty? Oh, that one, I found something that worked. Pretty excited, huh? I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection?
No objection.
Admitted. Among other things, sir, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments from the read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. So help you God.
Yes.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
And are you pleading guilty to this voluntarily, knowingly, intelligently, and upon discussions with your attorney? All right. I'm going to follow this agreement then and find that you are indeed mentally competent to do this. You are mentally competent to plead guilty. You understand and appreciate the consequences of pleading guilty to this third-degree felony of theft of services. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this indicted third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement is suspended and you will be placed on regular probation for 10 years.
Thank you, sir.
Now, there will be terms and conditions of probation, which are normal and customary for this type of offense. There will be a theft prevention class that will be required of you and other conditions which help you be the best you can be.
Yes.
Most importantly, there is restitution owed to the complainant in this case and U-Haul, who is the company he is associated with, as named here. Restitution is owed in the amount of $1,257.90. Now, give me a plan. You're going to get out of jail here.
Yes.
And what are you going to do in your life? Fix this, right?
Yes.
Okay, how?
Can I have set up a partial
Sure.
plans?
Yeah. Yes, sir. Do you have a plan of getting employment and income? Have you worked something out?
I'm on disability. So
How are you going to pay this?
disability, using my disability.
Are you able to do some kind of sedentary work? Not requiring a lot of heavy lifting.
Whatever I have to do.
Okay. Because it doesn't do any good if it takes them 10 years to get this money back. The quicker, because they've lost the money, they lost the use of it. So it's like interest. The cost is going up every day that they don't have their money. Okay. How much do you have a plan of how much you want to reach monthly on repayments? About how much you think you can pay when we release you and get you out there in the free world here shortly? Yes. Yes.
Disability.
That's good.
Yes, sir. Is that fine?
Okay. Why don't we do 150?
Yes, sir.
Okay, so we don't stretch it. Okay.
Thank you, sir.
You'll be ordered to pay no less than $150. If you're unable to do that, get with the probation office, your probation officer, who you will be meeting shortly.
Yes.
He's the head of the probation office in regards to communication with the courts. Very nice man, but he's not going to be your officer, but he'll go over everything.
Thank you,
But if you're unable to, that could result in a revocation. We don't want that. We want you to be satisfied in comfort in doing this, but also you've got an obligation to pay these people back as soon as you can. All right. So, and at 150, you're talking about a year.
Yes, sir. Yes, sir.
And then that takes care of it. But anything else?
Nothing, Judge.
All right. Please see the probation officer. Thank you. Good luck.
On Charter one, I think this was the hearing on his evaluation of tips. I mean, they got him evaluated. I think I got it with you, right? I know he was the guy who I think we all had agreed to meet with William. I think everybody agreed, Judge, that he needed just that intervention. That's Charter one. They evaluate him.
Jeremiah?
Yeah, that yes. I think you.
Where is he? He's in custody?
Yeah. Just the board, you know what I'm saying, too.
All right, what?
I think he's supposed to get, I know we had filed a motion to give him exam.
Hold on. Let me read it real quick. I said, he's before, what's?
He's,
okay, here's your motion, and the issue of consent has been raised in this case with respect to hereby made the disinterested from as there was competent evidence to support incompetency, as it were.
Yes, sir.
Defense of insanity. Okay. What do we have in the record that is the underlying facts that support this? It's because the motion is just summary. It's just conclusory, which it doesn't.
I think when we were here last.
I can't remember. What are you talking about?
We were here last.
Any objections by the state for this?
No, you're right.
It's granted. I don't have an order. You don't have an order?
I don't think I'll.
Okay, the court is going to grant this motion for examination regarding insanity. Is that all you're asking for?
Yes, sir. That's incompetency, but yes.
Well, I mean, that's a different issue altogether. Competency to stand trial and insanity, which is a raised defense, or apples and oranges.
I say both of them. I mean, you would, y'all.
All right, and then we'll we will order and prepare an order that the court will sign granting this motion for examination regarding insanity. And also, I'm going to expand the examination for competency as well. Based upon the information the court has, we'll put that into an order and get him analyzed. And then we'll all come back and see what the diagnosis is and take up further matters. Okay. But we'll get that into written form, and I will sign the order as soon as possible.
Thank you, Judge.
Yes.
Appreciate you.
I have Cyrus Sandy.
You can bring him out. I gave him his discovery and everything. The offer was 7 years, and he told me no to that.
Okay. Cyrus Sandy.
He's here. Yeah, he's here. Not did convey to him is to hand himself.
Okay, I call 25 CR 537, the state of Texas versus Cyrus Sandy. Is that you, sir?
Yes, sir.
Present with Mr. Adams, your attorney, and the state's attorney is present. You are charged with a third degree felony of fraudulent use. I'm sorry, illegal possession of credit and debit card information. And because it's less than 10 items, and this is credit information and debit card information of others, not you, without their consent. Which is a third degree felony, which carries with it up to 10 years in prison. You also, it's alleged here you have a prior conviction out of Titus County. Where's Titus County?
Mount Pleasant, Texas.
Mount Pleasant, is that the?
Titus County, Mount Pleasant.
Mount Pleasant. Okay. In the 76th District Court in 2019. And it says illegal possession of a controlled substance conviction. So if you were convicted of the third degree felony, and if this was proven true at the trial, then your punishment is no longer third degree. It turns into a second degree punishment. And that means you are facing up to 20 years in prison. So you understand where you are on all of this. All right. Did these 6 different credit and debit cards get back to victims or the rightful owners? Do we know? Y'all got possession of them, don't you, somehow? Or the state? They took it.
I got a picture of discovery of other credit. So I'm assuming.
So what are we doing on this then today?
This is a picture.
Mm-hmm. Okay.
Picture.
Thank you. Let me see that.
Here you go.
Let me make sure my name's not on any of this. Okay. All right. Where are we? What are we doing? He's not eligible for probation in front of a jury because of the prior conviction. So that's out. You can't get that from a jury. So if you tried this, of course, you're looking at up to 20 years in prison or not. So you can't get regular probation from but you can't. And they don't give deferred or unadjudicated probation. So that's not allowable at a jury trial. So that kind of puts him in a box here. But where are we on trying to dispose of this? Anything?
The offer was 7 years TDCJ.
How much was lost in this transaction? Anything?
I'm not aware of any law.
I'm not good. Not. Right. This case.
Good night, Kurt.
That's you, sir?
Yes.
That lady, thank you.
Help you God. And you got your right hand, Chris. Hey, Chris. Here, one more time. No, no. Let's see how.
Three cases are now called 22-40954 is a motion to revoke probation. That's the older case. And then there are two new cases that are newer cases, 25 CR 858 and 859. Does the defendant waive formal readings of the indictments and the arraignments in these cases? Can we proceed in summary?
Yes, sir.
Everything's going to run concurrently, correct? No,
Yes, sir.
This is all running together.
Yes, sir.
All right, I'm going to take up the two new cases first in order, 25 CR 858 and 859. In 858, and in these cases, the defendant waives formal readings of the charging instruments. We can proceed with summary. In 25 CR 858, sir, this indictment alleges that on or about March 5th, 2025 in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here for it in this case?
Yes.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed that cannot exceed $10,000. Do you understand the punishment range in this case?
Yes.
An agreement has been reached where you would be pleading guilty, sentenced to 20 years in prison to run concurrently with other cases. Is that your understanding of the agreement?
Yes.
What is he going to do on the NPR plea? Okay, so it will run concurrently with that case as well.
Yes.
It's not written here.
Yes, sir. All there. Okay.
So this would run concurrently with the next case we're going to go into 859 and the probation case that we're going to be handling in 22-40954. Is all of that true and correct?
Yes.
Yes.
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir, of this first degree felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily because you are guilty?
Yes.
Show you this marked as state's exhibit. When did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. I'm going to hold this in abeyance for just a minute. I'm going to go into the next case pending, 25 CR 859. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that Also on or about March 5th, 2025 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child by sexual contact. Do you understand what you are charged with in this case?
Yes, Your Honor.
But this is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in this case where you would be pleading guilty, also sentenced to 20 years in prison to run concurrently with 25-0858. And let me add this other motion to revoke probation case 22-40954. Is that all true?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this case as the previous case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
On each of these cases, I'm showing you what's marked. These two cases you have pleaded guilty to. I'm showing you what's marked as State's Exhibit 1. Did you sign those documents voluntarily? In each case, understand them, discuss them with your attorney, or the contents all true and correct?
Behalf of the state of Ohio. Mr. Presley, I've been handed a document. This document is called a jury waiver, and it appears to have a signature. Is that your signature?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And it is your conclusion that this is in your best interest to waive your right to trial by jury.
Yes, sir.
And you understand that you have a right, if you want, to be tried by 12 people. And if you want, we will pick 12 people, and they will listen to the evidence, and they must be convinced by the state beyond a reasonable doubt of every essential element of the offense charged in the indictment. And if they're not convinced beyond a reasonable doubt, they are required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
And you want to give up that right, and you want the case to be heard by the court.
Yes, sir.
And you understand still that the standard of proof is the same beyond a reasonable doubt. The state still is required to prove beyond a reasonable doubt each and every essential element of the offense charged in the indictment, right?
Yes, sir.
And that's what you want to do.
Yes, sir.
Okay. This time the court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your right to trial by jury, and I will accept that. And I will ask David if you go see Jennifer and set this for a 1/2 day bench trial.
Sounds good.
Anything else, Ms. Tranter?
No, sir. Thank
All
you.
right, we'll see everybody at the next hearing.
Thank you.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, these states you were mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in each case. All true, so help you God. State's Exhibit 1 in each case made a part of the record. Pre-sentence reports are waived here. On these two cases, I'm going to follow these agreements and find in each of these cases you have pleaded in 25 CR 858, the first degree felony of aggravated sexual assault of a child, and in 25 CR 859, the second degree felony of indecency with a child. You have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in these hearings to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of these two felony offenses. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years confinement. In each of these cases, these sentences shall run concurrently. What this means also is that you have additional obligations of filing documentation, and you are going to have to register as a sex offender. And because this aggravated sexual assault involves a child younger than 14 years of age, this is going to be for life.
Yes, sir.
You're going to have to register. And failing to register properly can result in the filing of a felony charge and additional prosecution. So you have an affirmative obligation. The probation officer, when they go over this judgment with you, you're going to be able to do that to explain to him. What do you need to explain, Judge? The obligations of registration under the sex offender laws. And do we do that immediately through y'all, or is that done through the jail? Because he's got to do that immediately. And I don't have paperwork here. How do we get that accomplished?
What documents specifically is it that we reviewed?
Sir,
What documents?
he's got it registered under the sex offender program.
I think,
and I'm not telling him how to do that. He just has the obligation. It has to get done. Somebody's got to help him with that. He's not on probation.
I think when he is released parole, I think they.
That's what he's got to do before he's released on parole. Right?
While he's in custody, I don't think he has a duty.
They'll handle it.
Until he's released.
Correct. So I agree with that.
So they'll take care of that once he's released.
Okay. Well, the prison authorities will know that he has that obligation, and they know what his convictions are.
And his parole.
They can take care of the necessary within the institution for security based upon those matters.
We do have the notice that's normally signed by defense counsel and the defendant today, Judge. That's on the tablet. That should be done. While you're looking at that, Judge, I've made contact with the family about the plea, but they weren't able to be here before the entry of the plea today. I will confirm that they still want to do an allocution, and we may schedule it later this week, Your Honor.
Did you do that, Mr. Dusel? We may need to bring the defendants back because they have a right under the law
They do.
to
Mr. Hamlin,
Yes, sir.
confront the defendant and allocute on what harm has occurred here. But I don't see anything in the tablet that.
I don't think it's been done by the defendant, Judge. I think it needs to be done.
In 22-40954, does the defendant waive a formal reading of this motion to revoke probation here? Can we proceed in summary?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. In summary, this motion to revoke probation filed on May 28th of this year, it states that on April 10th, 2023, in this court, you were sentenced to 10 years in prison, and that was probated or suspended for 10 years for the third-degree felony of theft of property. Is all of that true and correct, sir?
Yes.
So you were convicted, sentenced to 10 years in prison, placed on probation for 10 years And this motion alleges that you have violated that order of probation. I don't see anything. There are no allegations about the two substantive crimes he just pleaded guilty to. All right. Number one violation states that you committed the offense of illegal possession of a controlled substance on or about March 10th, 2025 in Hardin County, which was in violation of condition 1 of your probation order that states don't commit a crime. Is that true? Yes, sir. Are you pleading true to that voluntarily? Because it is true as it is alleged.
Yes.
Do you understand that a knowing and voluntary plea of true, one or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked and you can be sentenced to no less than 2, no more than 10 years confinement in prison. So for this third degree felony effect. Understanding that, do you insist on pleading true today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. And then finally is allegation 6. This states that you violated your probation by failing to remain in Jefferson County, Texas, and that you were in Hardin County, Texas on or about March 10th, 2025 without permission from the Jefferson County Adult Probation Officer Department or this court in violation of your probation order. Is that true?
Yes.
And are you pleading true to that voluntarily because it is true as it is alleged?
Yes.
And again, the same warning, do you understand that a voluntary and knowingly made plea of truth to one or more violations of probation, that is a grant, the motion to revoke probation? The probation can now be revoked and you can be sentenced no less than 2, no more than 10 years confinement in prison. Do you understand?
Yes.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily to this allegation as well and this motion to revoke probation, and you understand and appreciate the consequences of pleading guilty. An agreement's been reached where your probation would be revoked and you would be sentenced to 5 years in prison to run concurrently with these other cases. Is that true?
Yes, sir.
Stand by. Add this since this. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
Okay. This states the case will run concurrently. This probation revocation will run concurrently with 22-41105. I don't know what that is.
No, the was a prior motion to revoke state jail felony. He was previously sentenced to 2 years state jail.
You're asking it also run concurrently with these other two cases, correct?
Yes, sir. All right.
But that's not in here. Can I add that? If that right, that's okay with everybody?
Yes, sir. That is artist's intention.
Okay. I find there is sufficient evidence, again, supporting this motion to grant it by a preponderance of the evidence or greater as allegation 1 and 2 of the motion to revoke probation dated 5/28/25 in this cause number 22-40954. Those allegations are found true. Your probation is hereby revoked. You are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years in prison. And this sentence, in this case, shall also run concurrently with the sentences in cause numbers 25 CR 858 and 859 of 20 years confinement in prison that have been set earlier through the sentencing of this court in accordance with the plea agreements in those other two cases. Anything else to add?
No, sir.
That is all.
Here, Stephen.
Thank you.
Thank you, sir.
Thank you. Court has received from the defense sex offender registration admonishments, documents signed by the defendant in these two cases, and which state that the defendant had been admonished by his attorney, Mr. Dusler, that he has a reportable conviction, which requires sex offender registration under Chapter 62 of the Texas Code Criminal Procedure. And if he moves to another state, then requiring similar reporting requirements for sex offenders, he must register in that state. Failing to do these obligations can result in him being charged with additional criminal offenses. He signed these documents as long as his, as well as Mr. Dusler. Anything else to add, Mr. Dusler, on behalf of all of this? Thank you.
F. Steve Thomas, at plea.
Steve Thomas?
Yes.
Stephen Thomas?
Steve Thomas, please.
Please, thank you. Certainly not the Steve Thomas we know.
No, I don't think so.
File. You've got all.
Yes.
You've hijacked all the files from early. One case here.
That's our case.
Please right hand, please. Okay. Yeah, we swear our crimes to go through the whole truth and nothing but the truth, so help you God.
Yes, sir. That's what that is. That's what that is. Yeah. I'll have to serve. And just talking about that. There's
We now call the case of State of Texas versus Steve Thomas, also known as Stephen Thomas. That's you, sir. Present with your attorney, Mr. Dusler, and the state's attorney, does the defendant waive a formal reading of the indictment and the arraignment here in 25 CR 473? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about February 24th, 2025 in Jefferson County, Texas, you committed the second-degree felony of failing to comply with sex offender registration requirements, which require you to register in a regular fashion for life and for life based upon a conviction of aggravated sexual assault. Do you understand what you were charged with here?
Yes, yes.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years in prison or less than 2 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable here?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'll show you what's marked as State's Exhibit 1 there.
Yes, sir.
Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without interruption. I'm sorry.
No,
It's admitted. This states, Mr. Thomas, that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1. Made a part of the record for all purposes. I'm going to follow this agreement. Pre-sentence report is waived here. If nothing further, Mr. Thomas, I'm going to find you will pleaded guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. And you are guilty of this offense, correct? There is sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second-degree felony of failing to comply with sex offender duties of registration. And I'm following this agreement. As I find you guilty beyond a reasonable doubt, you are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You will be given credit for all time. Of course, you have served in conjunction with this charge. Do you understand what has happened today? Anything else?
No. Good. No. I already got him right here. There's I already got, I already don't do it right now. Can't be run together. You know what I'm talking about?
Unless I sentence you consecutively, by law, they run together.
Okay.
And I didn't, there wasn't an agreement that it runs on top of each other. So it will run concurrently by law.
Thank you.
Yes, sir. Heather Lane,
She's a plea judge.
she's a plea. Heather Lane. Thanks. Never give me any cash. It's always a case. This case file. That's all you have. No, there's no cash money over there.
I don't have any cash money.
That makes two of us.
I promise you, I'm trying to raise 2 children.
Yours or somebody else's?
Well,
Oh.
yes, yes.
You have some pets in there too?
2 cats.
Judge, while we're waiting to that plea, on the next page, there's a Michael Cup that the attorney needs to set on the trial docket. He's got to be in another county. We're just trying to get him out of here if we can.
Doing it fast as I can.
Yes, sir, I know. Not complaining, just asking if we can, because he's got a slow drive still.
You know what? What?
It's on the last pages of regular docket on the trial.
Raise your right hand. You swear at work on the television. The truth and nothing but the truth, so help you.
Yes, sir.
Please, can you have your right hand, Fred?
Okay. You need Michael Cups file real quickly. Let me look at it. Thank you.
Just let him know.
That's just the look of the draw. It doesn't come out at the top of the list. We'll work him as fast.
He's got some charges in another state that we're all trying to figure out. So, and I've got to talk to the victim in this case.
Okay, so we've got the defendant in 25 CR 512. That's who you represent?
Yes.
And you're going to be Mr. Newman?
Yes.
Right? Okay. This alleges third-degree felony of promotion of prostitution. And is he an habitual felon?
He is, Your Honor.
Okay, there's 3 priors. So
Yes.
generally, I bring them out on these. Bring them out real quickly. If you don't mind, Michael Cupp, CUPP. We're going to kind of, if you would just step aside just for a second, ma'am, and we're going to put you kind of in a rotation here, and we'll bring you. Just have a seat there in the jury box next to your lawyer. Thank you.
Taking me out of orbit, Your Honor.
Sure.
Shit. Gonna be in Brazos. I didn't realize it was that far of a drive from here. It's only an hour.
In Brazos County.
Two ways.
They're certainly a lot less friendly than we are.
That's where I grew up.
So this should be
So
good.
that's why you're hanging around Jefferson County.
I'm hanging around Jefferson County because of him.
Oh, you have an obligation here.
Trying to.
Come on up, please. Mr. Cup, that you come on up. Mr. Cup. Let us.
Don't be shy.
I recognize you because this is very unusual. The complaint has your big picture in the middle of the complaint. I've never seen that before. There it is. Right there. So I recognize you. You were here with Mr. Newman, your attorney, and as you probably know intimately, you are charged in this indictment handed up on May of 2025 here in Jefferson County, Texas, with the third-degree felony of promotion of prostitution. Do you understand what you're charged with?
Yes.
Carries with it up to 10 years in prison. You also have in this indictment, it is alleged a prior conviction in 1995 out of Harris County for burglary of a habitation, a first-degree felony. And in 1997, another conviction out of Harris County for the third-degree felony of theft. And that third-degree felony of theft, it is alleged, occurred after you were finally convicted of the burglary of habitation in 95. And then finally, it is alleged that after all of those convictions were finalized, it is alleged that you committed the felony of engaging in organized criminal activity, a first-degree felony, and were convicted of that in 2011 out of the 179th District Court of Harris County, Texas, which makes you what we call an habitual offender twice over. And you are looking at, if convicted here, no less than 25 years in prison up to life in prison. Most serious case, obviously, but you've got to navigate through with your attorney's help. What are we going to do today?
I would like to put it on the trial document for the commission.
You got it. And so we're putting on the trial docket. No deals then, right? Okay. All right. Then that's get this as soon as possible.
Yes, sir.
Okay.
Thank you. I appreciate it.
And you understand, I don't know if you're going to be serving any other sentences. If you're convicted, as you probably know, that the sentence, if convicted and sentenced, it will run consecutively to others. It can run consecutively to all other cases that you may be punished for.
Yes.
Okay, just so you know where you stand on all of this. Okay. Anything else? Okay, thank you. We'll set it for trial as soon as we get there. Thank you.
Where
is he? Come on.
With the potential plea, Judge.
We got to put something on the record.
Yes, sir.
Who is it? Who is it?
It's Uncle Jimmy.
Jeremy.
No, me to bring him in. I need to ask you a question.
Hold on, stand. .24 CR 2167 is called Jeremy. Is it Joe Ojimini?
Yes.
Pronouncing that right? Good. And what is that? Nigerian. Oh, that's a beautiful country.
Yes.
Anyways, you are probably know you're charged with a third-degree felony of assault on a public servant, which can carry with it up to 10 years in prison. You understand what you're facing? You have to speak out so she can take it down. Yeah, do you understand what you're facing? Okay. Mr. Samuel is here representing you, and he says that there's a situation that needs to be dealt with here before we can move forward in this case. I think there's a plan to get you some medical assistance here in dealing with this case and what happens next. As you have earlier been found in August to be competent to stand trial, which means you're free to come to trial. I think there are some other issues that your lawyer is looking at to make sure that he's trying to get you as healthy as possible. So we're going to have to reset for a few weeks. How much time?
2 weeks.
Is 3 going to be?
That's fine.
All right. Look, why don't we do 3 weeks, which should give it enough time to work these issues out. Make sure that you follow his advice. He's a smart guy and he knows how to help his clients. And we want you to be healthy, physically and mentally here to be able to move forward for an informed disposition in this case. Okay. All right. So he's here kind of like you're lost in the woods. He's tracked you down and he's going to bring you out of the woods safely. Okay. All right. Anything else?
Yes.
Okay. That is all. Thank you. You are free and we'll just get a resetting for you, Otwin. Okay.
Yes, sir.
Next is Reagan. It's who? Is it?
Heather Lane.
Heather Lane. I'll be on. Oh, there it is.
Page 3.
Page 3. 25 CR 655 is called the state of Texas versus Heather Lane. That's you. With Ms. Minaldi, your attorney, and the state's attorney does the defendant. We have a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about April 11th, 2025 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you were charged with here in the indictment?
Yes, sir.
This is a state jail felony, which means if convicted, you face no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand what you're charged with?
Yes.
And we're getting all these indictments out of this this last grand jury, and you can see the foreperson here has a real large signature. Yeah, so that the defendants understand and appreciate the seriousness of these charges. All right, a plan has been reached, correct?
Yes, Judge.
So plan has been reached here where you would be pleading guilty, sentenced to 1 year in the state jail with all time credited that you've served toward that sentence. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
There wasn't any restitution on this, was there? Because it's unauthorized use of a motor vehicle. A lot of times people take the car and then wreck it.
The car was recovered.
Okay. And again, how do you plead to this? Guilty or not guilty?
Guilty, Your Honor.
You're pleading guilty voluntarily and because you are good. Show you what's marked as State's Exhibit 1. Did you sign that document? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered
No
into
objections.
evidence. Without objection, it's submitted. Among other things, the states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a free trial and the rights to the appearance, confrontation, and false examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 made it part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I will follow this agreement. I'm going to find that you are indeed mentally competent to enter your guilty plea. You have pleaded guilty voluntarily, knowingly, and intelligently. Is that true?
Yes, sir.
To this state jail felony, there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here. to find you guilty beyond a reasonable doubt, and I so find you guilty beyond a reasonable doubt of the state jail felony, unauthorized use of a motor vehicle. I am following this agreement. You are hereby sentenced to confinement in the state jail for a term of 1 year. And again, will be given credit for all time you have served in accordance with this case. Understand what has happened to that? Good luck. All right.
Thank you, Judge. Thank you, Mike.
I have a John David Simeon Watkins.
He is pleased, well, Judge.
John David Simeon Watkins.
Or. The Watkins part. Yeah. It's Lisa's cousin.
Come forward, sir. And you need to see him over here to get a fingerprint. Thank you.
Raise your right hand, please. You swear or affirm to tell the truth and the truth, nothing but the truth, nothing but the truth. Your right hand.
Right.
Okay. One more time. Let's. Okay, this is perfect.
25 CR 51 is called the state of Texas versus John David Simeon Watkins. That is you, sir. With Ms. Manaldi, your attorney and the state's attorney does. The defendant waive a formal reading of this indictment and the arraignment here. In this case, can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about October 25th, 2024, in County, Texas, you committed of aggravated assault with a deadly weapon, namely an automobile. And a fence, which is interesting that it was used as a deadly weapon offense.
The dominant effect.
That's the way it's alleged. A second degree felony. Do you understand what you're charged with here? Yes, sir. You're facing a second degree felony, which means you face a term of not more than 20 years or less than 2 years in prison, in addition to finding it itself not to exceed the body. Really not science. Prison, 10 years in length, rather, and you do well, it's shortened to 1/3, as much as 1/3. And restitution is owed, and that is still to be determined.
And Judge, there may or may not be any. It's been a little while since I talked to the complainant. I'm going to call him back and see if there was any action.
What do we do today? Place him on probation, and everybody agree that restitution may indeed be assessed.
Yes,
and
yes, Judge.
I need though to assess that.
Yes,
so
sir.
at the
With
time,
the understanding that an amendment to those probation conditions might come with a proper restitution amount.
you understand where we are on that, sir. You could be paying restitution back, which is where you fix things on when it's loss of value of property. And the quicker you fix it, the quicker you get rewarded. That's all I want is put this back, put the victim back to hold. I don't know what that is. But is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? Yes?
Yes.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence, and without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with, and the indictment's been read to you. You've read it. You are guilty of the crime charged with any included officer. You were giving up your rights to a jury trial, rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer.
Yes.
All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived.
Yes.
I will follow this agreement,
Thank you.
if nothing further, and find you, Mr. Simeon Watkins, are pleading guilty voluntarily to this second-degree felony of aggravated assault with a deadly weapon, namely an automobile, and offense according to the indictment. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt.
Yes, sir.
But I am not going to find you guilty. I'm going to place you on deferred or unadjudicated probation, so long as you follow terms and conditions of probation, which are normal and customary for this type of offense. Probation officer is going to go over with these with you here in a moment. Make sure you follow these. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 20 years in prison, the full range. We don't want that. Also, restitution is going to be owed. We're going to figure out what that is. Everybody's agreed it is. You are liable for it. We're going to figure it out, and you probably are not going to be able to write a check for it. I don't know.
I don't know if there were any injuries. It was it may be to the fence a little bit, or and I'll see if he did actually have any hospital. I don't think he did. I think it was just maybe hit his knee a little bit, but I will just to make sure. Yes, sir.
Well, property damage.
There may that to the fence. I'm gonna see about the fence. It was
I don't think so. I don't think he was accepted.
Okay, it doesn't sound serious. The point, not to make it light.
It wasn't serious.
Okay, you would know. Okay, we're not there. You know,
Right.
we're not going to tell you anything you don't already know. But whatever it is,
Yeah,
the court's going to order you to pay back if you feel, oh, wait a second, $1 million is a little much here. I'll resolve it.
Thank you.
Okay, if there's a dispute, but restitution is going to be ordered in an amount all parties have agreed to be determined later if there is an issue, and that will be a part of the requirement for probation to be paid back as soon as possible.
Yes, sir.
And if you need some time, then we can give you some time on a zero interest payment plan.
Okay.
But the quicker the people get paid back and put whole again, the quicker your probation ends.
Really?
Yeah, boy.
Thank you.
I can finish it and suspend it and complete probation in 1/3 of the time. So 10 years here, 3 1/3 years.
Okay.
So,
Thank you.
if as long as you do your part. Okay. So see the probation officer, and hopefully good things will come about here for everybody.
Thank you.
Thank you.
Thank you. Thank you.
You're welcome. These are this been all nice.
Sorry. He's trying to find where he is on this. I can't.
It's my name.
I had it. Yeah, Christopher. Okay, I have, no, it's Simeon one.
Simeon.
John David.
John David. Those are Miss Manala's, other three. Page 3. See.
I lost page 2. Oh, we completed page 2.
Yes, page 2 is complete. I start on page 3. Oh,
I have Marcus Avita.
yes. I have spoken with the judge. I'm still reviewing the offer with him. He also
This time.
4 weeks.
Okay.
Please.
4 weeks. You got it. The request for additional time on Marcus Avila, it's 25 CR 277, reset 4 weeks at request of defense. In 25 CR 225, Leon Davis.
Judge, I've spoken with 88 Gasper about that case. I think I might be missing a body cam relevant to one of the police officers that were there that day. She's gonna look into it for me. If we could have 4 weeks to try to resolve that issue.
That's correct, Judge. There is an offer on the table.
Yes.
Said 4 weeks on that one. And Rex Powell, also Miss Gasper.
He is a motion to revoke probation.
Yeah.
He is going to voluntarily plead true to one of the allegations.
He just looks like
To number 3, Judge. So,
non-substantive type.
yes,
It's
they
not
are.
a crime.
He has a very high level of restitution if he has to pay back. I do have a interested party here on behalf of him that has a job set up for him if he was to be reinstated so that he can make payments.
Does he want to be reinstated?
He does.
Oh, okay. That's the important part.
Yes, and he is adamant that he will be successful on.
Where are we on paying it back?
He has not paid anything. He has not reported. He has not shown up to anything, done any of the classes or paid anything.
That we're running into.
It was
Has
this,
he been in jail?
Since.
Let's see what license said. I mean, he just walked off the job. You get punished.
So the issue that we ran into also, Judge, is you had ordered some upfront time for him to do, but he had trustee calculations. So they calculated his time. They gave him trustee credit for his days. So they have let him out. He reported to probation, but then they told him that he was not supposed to be let out, that he had those 35 days, day for day to do. And he went back and reported himself back to the jail to complete those 35 days. And then he was released January 22nd of 2025 of this year.
and from the time that he was released, Judge, he didn't do anything on
Yes,
probation.
there was no other contact with probation after that.
So he didn't report again.
He didn't report again.
Oh, okay.
And then this motion was filed in March of 2025.
How long has he been in jail this time?
He was arrested June 26th of this year. So 82 days as of today.
How much time does he have credit for so far? On this case? So we haven't,
Well, he has 173 days.
so we have not determined what the restitution is yet?
Restitution is $32,500, Judge, and has not made any payments towards that restitution as of yet.
That's correct, Judge.
And,
No.
Like, let's get the defendant out here. It's Rex Powell. You have a pre-sentence report from probation on this man. Come on up, sir.
Yes, sir.
And in 21-38457, you were Rex Allen Powell Jr., correct?
Yes, sir.
And as you know, you're on probation in this case.
Yes, Your Honor.
For the second degree felony of theft, third degree felony of theft, which carries with it up to 10 years.
Yes, Your Honor.
In prison. All right. So we have a loss in this case of over $32,000 to the victim, which is, um, I've never seen an affidavit for an arrest warrant so interestingly worded. This states that you stole $32,500 from the victim by using guile and deceit. Interesting use of verbs that we generally don't use guile, but it shows that the officer in this case took English classes, I'll tell you, through school. But we place you on probation here. I agree to this. And this was in December of last year. So we're headed toward a year, 9 months anyway, into this. And according to the probation office in the state, he hadn't done much anything. And there's a motion to revoke probation that has been filed now that states you failed to report to the probation office since December 10th. I placed you on probation the day before. Who does that? You walk right off the job. We hired you and then you left town. When was he placed in custody? When was he arrested? I'm curious. Anybody? No.
I think it Lacey said it was in June. But remember, he had those issues at the beginning of his probation where he was let out and then he had to go back to jail. So he went back and wasn't released from Jefferson County until January 22nd of 2025, which doesn't fix the overall issue. But I just wanted to remind you that he did self-report.
Yeah, the thing is, you know how important all of this was, that we're serious about it, because when we catch you, we throw you in jail every time. So then you leave. When did you leave jail the last time?
January 22nd.
January 22nd. And when was he arrested?
June 26th.
All right, 6 months later. All right. Where were you? You certainly weren't at probation.
Wisconsin. I was doing my community service. I was doing my community service.
What were you doing? What community service were you doing? Your own community service?
Sir, I did 87. Well, actually, I did 115 hours community service at Henry's place, but then they lost the paperwork, and now Miss Linda Court has the paperwork. I was in the process of getting my driver's license.
How many times did you report to the probation office?
Just the once, and because I went through some mental anguish because of I've never been in this situation. My dad got cancer.
What do you mean you've never been in this situation?
Never been homeless. I've never been. I ain't been in trouble for 20 years, and I apologize. I just want the opportunity to prove that I can't do this. And I was trying to get my new social security card. Certificate.
Hold on.
Yes, sir.
You're railing on, and I'm not going to let you look at me and lie.
I'm not. Yes, sir.
Raise your right hand. You solemnly swear or affirm any statements that you make during this hearing will be the truth, the whole truth, and nothing but the truth, subject to prosecution for perjury. So help you God.
So
lower your hand.
Yes, sir.
You hadn't been in trouble how long?
I think it was about 17 years.
17 years. 2012, you were convicted in, was it Dare County, North Carolina? 6 to 8 months confinement.
That was the last time.
No, wait.
Yes, sir.
Do the math. That's 13 years ago, mister.
I'm sorry.
You're going to look at me and lie? You can't do math above 13 years?
I'm just bad with time perception. I'm sorry.
Oh, are you?
Yes, sir.
Yeah, I think you're bad with truth perception.
Yes, sir. I'm sorry.
No. And we've got, let's see, non-support, Dare County in 14, failure to appear in 2012, failure to appear in North Carolina, DWI in North Carolina in 2011. All that's within 20 years. Your earliest crime is 2002 conviction in North Carolina, 2002. And let's see. I've never seen this one. A felony of littering with using, you littered more than 500 pounds of debris and were convicted of that. That was some kind of littering.
Use a vehicle.
And then you get this illegal possession of a controlled substance on the prison or jail premises. Are you kidding me? Who does that? And then convicted for that. All right, now you have this felony theft. And we put you on probation after all of that mess. And you walk right off the job. You just don't seem to appreciate the seriousness of what goes on in a criminal courtroom. Plus, you're just plain dishonest. You've shown that this is what you do. You deceive. And what was the words in this probable cause that the officer used? Let's see. You're using guile. And deception in this courtroom. Anyway, enough of that. So there's a motion to revoke probation. What do we plan to do?
Judge, the state has offered pen time in this case. Given the situation and the hefty amount of restitution, we wanted to bring it to your attention before moving forward in any way.
Okay. What we're going to do is, I'm not accepting any deal. We're going to have a motion to revoke probation. And that's where we're going to head. We can plead true or untrue, and the state will be obligated to present evidence, and the court will make its decision. Okay. Anything else?
That's it, Judge.
When can y'all be ready?
2 weeks.
You got it. 2 weeks. Good. Thank you. Yeah. That is on. See you in 2 weeks. So I guess he's got no bond right now, right? What's his
He does not have one set, but he is on deferred, Judge, so he is entitled to one if you would set one, please.
$1 billion
That's fine, Judge.
plus GPS device
2 weeks.
plus home confinement? No. Let me ask you, hold on for just a second. God West, I've got Kizzy Landry and Kinsey Taylor.
Yes, Your Honor.
Ms. Landry's one that you last week, let her continue on probation, her to get out to prove everything, but she's still being held by misdemeanor. So just years.
By what?
A misdemeanor.
Okay.
Yes, it has nothing to do with us.
Well, let me know when that happens.
Yeah, and I'm gonna check on it this week to see what's going on.
Taylor?
Quincy Taylor, going to get about 4 more weeks.
Just a plea.
I know, but he wants to think about it, or 3 weeks, wherever the court feels. Give him some time to, I feel like it's going to plea.
Can we do it in 2 weeks?
2 weeks is not too bad.
All right. We said that 2 weeks. Thanks. Roger Carter? I thought that was Mr. Burbank. Is that the, am I the?
Thank Mr.
Roger Carter?
Let's call the motion to represent.
But it was it, was showing Mr. Burbank on the document.
Always shows Mr. Burbank.
Kimler? Mr. Kimler? It's essentially read.
About that.
Okay. Who else?
I have one, Judge.
Where? I don't see it.
It's on the trial docket, but it's not a case set for trial.
Yeah, it somehow ended up on the trial docket for an unknown reason.
Adria Richard, about halfway down on the trial docket.
Really?
It's right here. Yeah, we talked about it. I don't know how it ended up on the trial docket.
Well, what's this supposed to be?
Well, it's just a status review, Judge. She's on probation.
Okay.
And so.
Is the probation officer here? Okay, it's a status conference on this?
It is.
That's you.
Okay.
22-40703 is called the State of Texas versus Adria Marie Richards. That's you, ma'am? Mr. Galmore's here, and the probation officer is here. You were placed on probation last December, correct? 10 years deferred or unadjudicated probation. And there was restitution. Is this, I guess, what this is pretty much about?
Yes,
trying to get the money back to the people who are the Porter Community Federal Credit Union people, right? Where are we?
Well, Judge, I believe that everything is going well on probation. However, she had substantial periods of time with unemployment. She started.
Where is it? Where is it now?
She works at a school. What's the name of the school?
Yes, Brett. Yes, Brett Public School.
In Houston.
Oh, in Houston.
Yeah. And so she believes that her first official paycheck, she'll be able to completely be current on all of her fees with probation.
It would not completely pay it off.
Will not be able to completely pay it off.
Okay. With this financial situation now, what are you able to pay a month on this?
Being it's 400
You're gonna be able to continue to do that?
and probably a little bit more if I can.
Well, all things being the same, I can't remember what the pre-sentence report was. Do you have a criminal history other than this? This is it?
This is it.
Well, this is the key. Get it paid back as soon as possible, all things being the same, and then it gets dismissed, which is the best outcome that's possible. But the people, they lose. And when it's a credit union like this, the depositors get hurt.
Right.
So there's a large amount of victimization here because everybody pays for increased costs to the bank that they have to pay for because of the loss. Well, that's hopefully inspires you to work real hard to pay it back as soon as possible. Okay. And probation, anything else?
Yeah, sorry. Just to reiterate what Mr. Galmore said, that she's doing well in all other areas. She has some small arrears as a result of her unemployment at the beginning of the year. She has assured me that with the next check that she gets, she should be able to get current of the $1,500 that she's currently delinquent. So she is making monthly efforts. They're not quite meeting that $455, but I feel like she'll be able to get that all rectified.
That's important. So how much has been paid so far?
towards restitution.
Yes, ma'am.
$1,445.
The total,
The total that she has paid and been credited is $2,305.
and the total loss again was
Was $45,368.97. I have a copy of her financial record if you'd like to see it.
Of course, if you pay 400 a month, we're talking about 100 months. That would take to pay that, which is 8 years. But okay, maybe something can be done to hasten this because it's good for everybody, including you, to do that. Okay. But let's review it in 6 months. Yes. You think? Okay. Review it in 6 months. Please get a resetting. Thank you, ma'am.
Thank you.
Yes.
Yeah.
Thank you.
Tom, who do you have? What do you want?
I have Mr. Fontenot here. I was on the job.
It's a pretty nice.
Okay. Cedric.
Yes. Sir. And afterward, we do have one family member that wants to allocate.
Okay.
I'll need to swear him in or fingerprint him.
Cedric. Is that you? Yes, sir.
Mr. Wright, you swear on. Proven and everything stuff like that. Okay, you get the number.
There's Roger Carter's on this one. I don't know what the Roger Carter deal is all that.
There's a writ on that in here. And actually, that's, you want to see if he'll come back here.
Twenty-three CR 229 is now called the State of Texas versus Cedric Jerome Fontenot. That's you, sir?
Yes, sir.
Present with your attorney, Mr. Burbank, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does in your mail, Your Honor.
In summary, this indictment alleges that on or about October 25th, 2022 in Jefferson County, Texas, you committed the second-degree felony of manslaughter by recklessly causing the death of an individual, namely Jonathan Allen Brody. Pick up the phone. God. The sign can't be any larger. Don't bring a phone. Everybody's got a phone, I know, but everybody turns it off like they should. And that's just ridiculous. We're at the bellow out like that. And it is further alleged in this very serious case that you operated a motor vehicle in an unsafe manner while using a cellular device and causing the motor vehicle to leave the road, cross over, and causing the motor vehicle to turn over and strike another motor vehicle operated by Mr. Drody. And thus, it is alleged that you used a deadly weapon, namely a motor vehicle, that was capable of causing serious bodily injury and death, and did cause that in the commission of this offense. Do you understand what you're charged with here, sir?
Yes, sir.
A second-degree felony means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
So,
an agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $750. There will be other terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the agreement?
yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, this second-degree felony of manslaughter, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Did you understand it, discuss it with your attorney?
Yes, sir.
Is everything true and correct here?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Objections.
Without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. And again, pre-sentence report is here by way.
We do, the family's here to do it, so we asked her to be.
Stand by. Is there a probable cause affidavit filed in this? I don't see it.
I didn't have one. I thought about it.
Don't know if there was one, Judge. Let me make sure. This was a great picture. Question, I don't know. No, it's. Usually is.
All right.
1 second.
Anything else anybody wants to add?
No, you're on.
If not, if nothing,
Sorry for what's happened.
well, you can understand when somebody is injured, seriously injured, or a life is taken, you don't have the ability to bring it back. And a sorry doesn't bring back the life that the people want back. I'm looking at the information that I have in this case file, and it shows that since 2012, you have been convicted of over 20 motor vehicle violations. Speeding, no seatbelt, speeding, failing to drive in a single lane, speeding, no seatbelt, running a red light, no seatbelt, wrong color stoplight on your vehicle, no seatbelt, speeding equal to or greater than 10% above the posted, no seatbelt, no seatbelt, driving safety course. You've had at least 2 driving safety courses, I think, that you had to take, right? Failing to drive in a single lane. A non-injury accident in 2012. A non-injury crash in 2016. And then this in 2022. 20 violations. Now, this is what I've had my whole life. I mean, and I'm not special. It's not that hard to follow the rules. It's only a 4,000-pound missile that you're weaving through traffic in. A 4,000-pound missile, which has to be operated safely. So not only for yourself, but all the other people who rely on your safety. But over 20 years, since 2012, I mean, that's 13 years, 22. I'm just going to tell you, you look like, it appears here, you don't care about anybody else. Everybody else is just victim, a potential victim. My goodness, nobody in this room probably has that voluminous, irresponsible behavior shown in all these tickets, accidents, and then now someone's dead. You can add remorse to the equation all day long. You should have been sorry the first time you got a ticket in 2012. But you didn't, you've been making mistakes as quickly as anybody else, irresponsibly as anybody else I've ever seen in operating a motor vehicle, which means you don't care about others. That's not humane. That's not the way we all make it. We don't make a contract with each other, but it's kind of like that. We have a duty, even though we sign a dotted line, we have a duty to safely operate 4,000-pound missiles so that others aren't put in harm's way, as well as yourself and your family, which you just seem to irresponsibly couldn't have cared for at all. You just didn't care. And here you are. And then you got grieving people who can't bring their loved one back. And too often these are called accidents, which minimizes the irresponsible behavior. This, you can call it an accident all day long, but this was inevitable. Someone who was going to get seriously hurt or killed, if they hadn't already been, by your irresponsibility. So, there you are. Anything to add by anybody? Okay, I'm going to follow this agreement. I'm going to find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here that finds you guilty beyond a reasonable doubt. But the agreement provides that you would not be found guilty. You may be placed on deferred or unadjudicated probation for up to 10 years, and it will be for 10 years. There will be terms and conditions of probation which are normal and customary for this type of irresponsible behavior. You're going to be required to take safe driving program course and pass that. There will be other terms and conditions of probation that are, there are no less than 35 of them here. But a lot of these aren't going to be applicable exactly to you because of the nature of this offense, but most of them will. I'm not through. When you put our creators, humans, in harm's way irresponsibly like this, you pay a price. Somebody died as a condition of probation. I can sentence you to 6 months in the county jail, and I'm doing it. That's the most I can do. You think it's funny? Of all of this, and you're going to grin at me? You're going to think you think this is, it's a grin. I know what a grin is. I'm old enough to know what a grin is. You think this is funny, sir? I'm not grinning. It's a message. It's symbolic because we can't bring the life back. But you have been irresponsible for so long with a motor vehicle. It was inevitable. This was going to happen. And if you had a clean record, and this isn't an accident, what you're indicted for that you pleaded guilty to, recklessly causing the death of an individual, recklessly, which has its definition under the law. Get it word for word. Just, I see, all we do is deal with humans here, humans, and it has to be, you have to deal with them fairly and responsibly with the folks. But also, you can't hurt humans, and you can't put them in harm's way irresponsibly. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or a result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. That definition is not an award. That's a cruel, unthinking, unappreciative act toward others that you put in harm's way. And look, here it is. And that somebody has died. What this court tries to do is be fair and impartial, but when the result is the death of a human, the court is going to set the standard I've always said, and the price is high when you are responsible for the loss of a human being's life. And you're going to jail for 6 months, and it will not just be punishment for you, but a symbol for others that they face 6 months in jail, which is hardly fair for the eternal loss of life. You didn't intend to do this. And I'm sure it's a terrible thing to have to deal with. But my goodness, why didn't you fix this 22 violations ago? We wouldn't be up here. Family all upset. You're upset. We're all upset. Nobody, if we could have talked to you the moment before you got in that car and urged, something bad is going to happen down the road. Cedric Think about it. Be responsible. Another human being or yourself. We're going to lose a human here. You'd have done. I think you would have tried to do something responsibly and been more careful. That's what. There are only limited things the court has the power of, and it's not to bring back life. Wish I did. Too often that sort of thing happens here. But the court can try to act responsibly in the determination of the punishment, and putting you on deferred probation is what most people get in here who haven't caused the death, much less even physical harm to others. They get deferred for nonviolent acts for the most part. But this has its place. And I've always thought the DA's office acts responsibly in what they do, and they know more about this than I do. But this court feels like with deferred probation, this condition of probation needs to be added, which is serious. And I don't know, I'll give you an option too. You can serve it on weekends, or you can serve it day for day. If you're going to serve 180 days, you get 3 days credit per weekend. You can do that 60 weekends.
You want to do that?
Yes, sir.
I can guarantee you that that's more punitive than day for day. That's what people say, but it gives you an opportunity to go out and work and try to pay some.
Is that Friday at 6, Judge?
Yes, on or before 6:00 p.m. each Friday. And look, he's placed on probation, and the one thing that's not here is any restitution.
That was all worked out in a civil case, Judge.
Is that right? Is anybody from the victim's family here? I know financial is not what y'all are. But did you get fair
That was never mentioned to us. We didn't know. Any kind of restitution from him, we didn't know nothing about. It was never mentioned to us.
No, but
his wife came in and talked to us before. He was married at the time, Judge. The wife came in, we dealt with all that. When I talked to her. Okay, you talk about my son's wife. We have no dealings with her. I know that, but that was when I first came in. It was all that was through her. Okay.
Hold on.
Are y'all out anything in pocket?
Or you don't know?
No, we're not out anything in pocket. We are not doing it.
Because I can hold that condition open for further information if you feel like it's necessary. But if
I would like that.
Because
they need to understand this is not for pain and suffering or anything like that. That's civil stuff. This is
that,
for out of pocket or anything that costs any money. They're civil or anything. I think that's all been resolved. Look, I'm not going
to put y'all under the gun here on this. If
employers, which that's not, to me, that's not the purpose of this this petition. Am I missing something? Is that sound? Am I accurate in that, officer?
Yeah, that's accurate. I mean, his status as a sex offender will trump in the CQE when he goes for employment. The CQE is not going to allow the employer to employ you if it's against their hiring process.
Yeah, this is something that just says that, I mean, what you're asking me to do, in essence, is you're asking me to vouch for your credibility to future employers, which I'm not willing to do. Now, if this were some other type of offense and you were trying to get, let's say, you wanted to be a beautician and you had a theft offense and you couldn't get certified as a beautician with the state of Ohio because of this theft offense or whatever it was. That's something separate. I don't see that you're using this. I guess from my perspective, is the state having a position on this?
I would not disagree with anything the corridor director Binger has said. I don't know. I think it is essentially asking for the court to vouch for him, and
Yeah,
I don't know that that's appropriate.
Yeah, I just don't see that this is the proper use of this avenue.
I didn't know.
I'm not blaming you. I'm just saying that.
Oh, yes, I was released a little over 7 years ago. And I know now there are postings in the different dorms and that of different prisons on how to get the certificate to find work. And so that's really all I know about it. I did all the paperwork and I had to send it to the state of Ohio up in Columbus, DRC. And they okayed it and everything, and they sent it back to me and told me to bring it here.
Yeah, I'm reading your petition, and it said, I can't even read what it says. I literally cannot read what the petition says, the purpose for the petition. Can you read that?
Are you talking about this page here?
Yeah.
I think it says see attached as in the application.
But there's nothing in there other that tells me what it is, the purpose of this, which again goes back to my understanding of the purpose of this particular avenue to get this certificate is not what you're using it for. So,
right, well,
Page 3, it says, I want the certificate to help me find a job. It is very hard being a sex offender. The certification will open employment doors that are currently closed to me because of my offense.
now when I did the petition and that, it didn't say anything in there that you had to be handicapped or anything else.
this has nothing to do with handicaps. Like I said, this is when your conviction, and again, I'm not suggesting that your conviction is not a collateral sanction I think it's pretty easy to anticipate that would be a collateral sanction, but typically we see these when it is for the state of Ohio has a rule for some sort of licensure that the state grants. We see these types of petitions that says this person has fulfilled the requirements, and that we allowed the state to go ahead and grant the licensure despite the conviction. But that's not what you're asking me to do. You're asking to basically, again, my opinion is you're asking me to use me as a reference for future employment, which I'm not willing to do.
Okay, I would have thought that, I guess you guys are the prosecution.
You have a prosecutor sitting right there. She's
Right.
an assistant
Did
prosecutor.
you talk to Detective Abshir?
I did not talk to Detective Abshir. I did call the Thorn desk to check on the registration, but beyond that, I've not spoken with Detective Abshir.
See, I will agree with you, Your Honor, that it does sound like I want your, official okay to do this. Because I am a sex offender and getting this would make it easier for me. But, I'm also, besides being a sex offender, which is the worst part of it all, I have macular degeneration. I'm going blind. And so that's a handicap. And I also have hearing aids.
Yeah.
And then my age.
One thing you could do, there is a place over there on Silver Street. What's the address of the old courthouse? Everybody know? There's a place over there called Ohio Means Jobs.
Yes, I've been there.
Those are the people you need to talk to. There's nothing that I can do to help you get employment. I saw that your case was this a Bronson case gone to ODA? Is that right?
Yes, that was over a different issue.
Well, I understand that. I understand that issue. I went back and read that file, so I understand what that issue was. But again, Judge Oda probably knows more about this case than I do, because he had to have researched the motion you filed with regard to the offender status. But,
right.
But again, what I'm looking at here is this is not the proper. This is not the correct thing for me to do in this instance, because again, my understanding of this avenue is to assist in getting certification through the state, which you're not trying to do. So I just can't do it.
All right, well, I understand what you're saying, and I do agree with you that it's basically you saying, yeah, you're a great guy here. But earlier you said you would do it for someone who was a robbery or murder or whatever, or nobody.
I would not do what you're asking me to do. No, you're correct. I would not sign one of these for someone who just wants to basically use it as an employment reference. That's not the purpose of this. The purpose of this was when, again, my understanding is that when the state of Ohio requires a certificate in order to operate or be involved in a certain business. I threw out the beautician there because they're required to be licensed by the state of Ohio. What are some other ones that require licensure?
Teaching,
nursing. Yeah, we had a young man in here, I think just a few weeks ago, that was going to be a firefighter, and he basically, he still has to do all the training and everything else, and this only allows him to go and seek his certification through the state of Ohio despite his conviction. And I think he had a misdemeanor. It was something very, very petty. But I signed that so that he could go get his certification. He still has to do everything else. But what you're asking me to do is not that. So I'm going to decline your request. Okay.
I agree with you, and
what I would suggest you do, sir, is go back over to Ohio Means Jobs, because you have this conviction, but you also, and I know they work with people with convictions, but you also have a handicap. And that might be the best avenue for you to get some sort of employment.
Right. Well, I do understand what you're saying, and I do agree with you that if we had the places were changed, I wouldn't sign your paper either,
I understand.
So I'm not putting my neck on the line.
I understand. Thank you, sir. Appreciate it. Have a good day.
Okay, that's it?
Yes, sir.
All right, well, thank all of you.
Thank you. It's 300 Silver Street if you want to take a go over there and Ohio Means Jobs.
All right, thank you.
Thank you.
All right, this is case number 25CR42993, the state of Ohio versus Samantha Myers. Ms. Nicholson, I have in front of me a nollie signed by Kevin Hardman.
Yes, Your Honor.
Anything else for the record?
No, Your Honor.
All right, the court's going to sign the entry granting the nollie of this indictment. Thanks, Amy.
You're welcome.
I'm going to hold this open to consider restitution if information is received, because it seems like the surviving people here are just the surviving relatives. I don't think you're thinking about that right now. You're thinking about other things.
I don't mind, Judge, if you want to hold it open, but I'm
going to hold up to see, give them a little bit of time to make sure that there isn't a restitution issue. Because generally those things get resolved in the non-criminal end of things. People have insurance. Did you have insurance at the time, sir? You have insurance?
And he worked for a company that who was on the job at the time, so that was dealt with then. And there was a letter sent out.
But I'm going to give y'all a few weeks to see if there's something that was not a T not crossed or an I not dotted.
Yes, sir.
Financially, so that the family can be recompensed properly, fairly.
Unfortunately, under the time that this accident occurred, the next of kin was his wife. And so we dealt with her.
Okay.
So
the wife was going to be the primary person who would be speaking for, but y'all let me know if there's something that was missed, please. And the court will do what it can under the law. When can you begin?
This Friday, Judge.
All right, so it will be on or before 6 o'clock PM each Friday, and then they release you this Monday morning. And where are you working now, sir? You're not employed? No, sir.
He had home confinement. He does have a monitor which will be released and he'll be able to now go work. He lives home with his mom.
All right. This, when the loss of life is the subject matter, it's difficult for everybody. Is there something we're missing that we need to deal with?
One last thing, if we could sit over in the box right there, I believe someone wants to say something.
Yeah, we do have an allocation we need to deal with, but there was no alcohol in the system at the time. If the judge is worried about that, it was just caffeine.
No, I'm just,
But
if
there's
there's
nothing
any
else.
other reason that may have been the cause of this that I need to deal with.
No, Your Honor, that was a lot of factors.
All right.
We're not.
All right, then we're recess on that.
We do have the one allocation from brother, I believe, wants to speak on behalf of the family.
All right, yes, sir. And just if you would be so kind to introduce yourself and how you're obviously a sibling.
Yeah,
the deceased.
I'm the middle child. He was my little brother.
Yes, sir.
So we were best friends. We shared a room for 16 years together. So
Did y'all grow up in Groves?
we grew up in Binder.
Yes, because I knew the Drodies in Groves.
Do I start? Okay. I have it written down here. And when I showed this to my family, my brother, my parents, they said they didn't feel like anything else needed to be said. So we're in unity on this.
Right.
Jonathan, like I just said, he was my best friend, my little brother. No man knew me better than Jonathan, and no man ever will, because I can't go back and grow up with somebody again. With that being said, Cedric, I forgave you pretty quickly. I'm on the autism spectrum and I have a strong sense of justice. I need you to know that, because by my nature, it doesn't make much sense that I could forgive you so easily, especially given who Jonathan was to me. But I believe the fact that I feel the way about it is nothing short of a miracle from God. Before we learned about this plea deal, my family and I, we prayed for you in this situation. We didn't pray for punishment or for judgment. We prayed that whatever the outcome of this, that you would come to a place of repentance. And that's still my hope in all of this. You'll be on probation, can't come Sundays for a while, but I want you to know that if you need help staying on the right path, you can come to Eastgate Church where my wife and I attend, and we would welcome you, and you'd have an open invitation to sit with us anytime you wanted to. We do have church on Wednesdays, so you can make that. More than anything, we hope this is a wake-up call. That was what my mom really wanted to say. And we hope that you find peace in everything that happened and everything that you have to deal with. That's it.
All right. Anything else? Does anybody else in the family do anything closer? All right, we are in recess on that case then. Thank you. Anything else? Did you have another case, Tom?
I had come.
And Roger Carter.
That's fine. That's not mine.
Oh, that's yours.
No, it's not yours. Right to direct letter.
Why not? I said, oh, he said it was his.
Yeah.
It's not mine. I'm gone though.
Okay, Roger Malloy.
I already got this guy around with it.
Harder.
So right in. Right, house.
Time is jury coming back today.
At once. They start.
This one.
Okay, Roger Carter, please. Thank you. All right, we now call 25 CR 886, the state of Texas versus Roger Malloy Carter Sr. You're Mr. Carter?
That's, he needs to sit, he needs to.
Okay.
I'll see you with the judges.
Yeah, they can bring the wheelchair.
So you were here with your attorney, Mr. Kimmler. Anybody from the state here on this?
Mr. Lynch,
You were supposed to be my.
Harmless. Yeah, he's probably talking about phone. Yeah.
I got it. I'll do it.
Okay, the stop is here on behalf of the state. Go ahead. There's a petition for writ of habeas corpus filed by the defense on September 8th of 2025. Go ahead.
for purposes of the record, I assume that the application for the writ has been granted in this hearing to determine whether the relief requested therein should issue. Is that correct?
Yes.
Your Honor, bond currently is set at $1 million. This is a murder case. I'm prepared to offer testimony from Mr. Carter's wife regarding the financial circumstances, ties to the community and safety of the community at this time.
Go ahead.
I'll call her as a witness.
Go ahead.
Melissa Carter. This way, over here.
Okay.
Wow. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Speak up.
Yes. Please tell us your full name and how you are related to any of the parties in this case.
I'm Melissa K. Carter, and Roger Carter, Malloy Carter is my husband.
Okay, go ahead.
Ms. Carter, how long have you been married to Roger?
We've been married for 2 years, but we've been together for 42 years.
42 years. 2 years ago, you formalized that relationship through marriage. Is that right?
Yes.
Throughout that time, have you cohabitated with Roger Carter, lived with him?
Yeah.
Have you lived with him for
Yes.
the entire time?
Yes.
I understand he's charged with an offensive murder. Is that correct?
Yes.
And his bond currently is set at $1 million. Is that right?
Yes.
In connection with that, did I ask you to get some information from 3 different bonding companies?
Yes.
Regarding how much they would charge you and other conditions that they would require to post a bond in the amount of $1 million?
Yes.
Did you contact those bonding companies?
Yes.
Which 3 bonding companies did you contact?
Allied, Reed, and Bell American Backbone.
And what did each of those 3 companies tell you regarding what they would require to post a $1 million bond?
Allied and Bell American, they don't use collateral. Each one of them said that with the $1 million, it would be $1,000 down, or it could be $75,000 with a good cosigner.
How much down?
$75,000 with a good cosigner, with just the $1 million bond is $100,000. The $100,000 bond would be $10,000 down, and not taking.
Let's do that in a minute. I'll start with the $1 million bond.
Okay.
What did each of the bonding companies tell you regarding the $1 million bond? Start with Allied.
Allied, he had to have a good cosigner. Al Reed,
How much did they require down?
$100,000 down.
And the co-signer?
The co-signer is $75,000 down.
With the co-signer, 75,000?
Yes.
Okay. And they would finance the 25,000?
Yes.
All right, what about Al Reed?
Al Reed, no quote given for the 500,000 or the $1 million.
We're just doing the middle, so they wouldn't even give you.
I'm sorry.
They wouldn't even give you a quote for $1 million?
Because they said that the conditions would be too strict and they didn't want to put, be up under that kind.
They weren't even willing to write it.
No.
What about, the last one, did you say Bail America?
Yeah, and they don't do collateral and you must have multiple co-signers.
How much did Bail America require now?
It required the $100,000 down for the $1 million fund.
And multiple co-signers.
And multiple good co-signers.
So they were not willing to finance the down payment of $100,000.
Yeah.
What about the $500,000 bond? Same question for each of the bonds.
Well, Ally said $50,000 and it was still with a good co-signer. Al Reed, they did kind of, no, they don't want anything to do with that. The $500,000 or the $100,000 because it had to be evaluated under strict conditions.
And what about Bail America?
Bail America, they said $50,000, and they didn't say anything. They said that they don't use co-signers. Collateral. All they use is co-signers.
But they wanted $50,000 down.
Yeah.
Last question. What was the amount of the bond? The last question that I asked you to check for.
The $10,000 to $100,000.
$100,000 bond. What did Ally tell you about a $100,000?
$10,000 down with a co-signer.
And they weren't willing to finance the $10,000. Those up front, is that right?
Mm-hmm.
Answer yes or no?
Yes.
What about Al Reed on a $100,000 bond?
Al Reed said that they would do between $10,000 and $15.
What?
15? 10,000. I'm saying it backwards. $10,000 with a good cosigner. But at Al Reed, she said that if it can get down to $100,000, she said that if I'm not in a state where I couldn't pay it, and I'm not in that state, I am in she would try to work with us.
Oh, the amount of the down payment.
Yeah.
All right. Did she say how much of the $10,000 you could put down and how much you could finance?
No, she told me to call her when we.
If the bond is gone.
Yeah.
What about bail there? What did they tell you about $100,000 fund?
The same thing, $10,000, but I still had to have a good cosigner.
And as far as the $10,000, were they willing to allow you to finance that, put some down and pay for it?
They wanted the whole $10,000 and had the cosign.
Yeah. All right. What is your financial condition right now? I want to know savings, checking, real estate, stocks, bonds, vehicles, whatever you've got, liquid assets.
Have any vehicles? I don't
know what you don't have. What do you have?
Nothing.
And do you rent or own your own house?
Rent.
Do you own your own car?
No.
Do you have a vehicle? Do you own a vehicle? How much money do you have in your bank account?
Negative $550 something.
And anything else of value that you have? You have like a rare stamp collection or any kind of anything you can turn into money, anything you can take to a pawn shop and get money for. Generator, chainsaws, anything like that you could turn into money. How long has Roger lived in Jefferson County?
All his life. He was born here.
And where do you all live?
On 13th Street, 46, 47, 13th Street in Port Arthur.
Port Arthur, Texas. And how long have you been at that address?
For 24 years.
So he's lived at the same address for 24 years?
Yes.
And is he employed or what does he do?
He's disabled.
What other ties to the community does Roger have, to your knowledge? Does he go to church here? Does he have family here? Does he have
family?
What family?
He attend church from time to time.
What church you attend?
That's I had a stroke. I got a kid. Mount Calvary. I just drive to it. I don't.
Yes, ma'am. What about as far as other family members?
He has 2 sisters and a brother that's still living. Everybody else is deceased.
As far as his medical condition, what's your knowledge about his medical condition?
He has COPD, streaking in the lung from asbestos. He has ulcer on his left great toe that has not healed. It healed a little bit, but it keep bursting back open. And he has an infection in the bone of that toe.
What else? We're gonna keep going.
He has
high blood pressure,
diabetes. He has kidney problems.
That's vision.
He has glaucoma.
Pretty bad shape, would you agree? What's the name of his home health provider? Amy
Campbell.
Amy Campbell. Now, I represent to you, I've spoken to Ms. Campbell, who wanted to be here, but was advised by their lawyers that HIPAA would preclude her testing. But she's his home health nurse, is that right?
Yes.
Are you aware that, how long has he been in jail?
Since the 7th of July.
And during his jail time, was he hospitalized?
Yes.
How long was he in the hospital from the jail? Was he transported to the hospital from the jail?
I know he spent a little over a week one time. And the other time that I know of, he spent like a few days in there.
The jail would have those records when he was actually in the hospital?
Yes.
If he's released, if you post a bond and he's home, would you make sure that he gets his medical care and he attends all his court dates?
Yes.
You vigorously contest the allegations that he's not guilty of this murder. We want a trial. Is that right?
Yes.
I pass witness.
Were you there during the murder?
No.
Okay. So
But
if there was somebody that was there and that saw your husband or another individual get out with the victim in this case, they heard multiple gunshots and only the 2 of them got back in the truck and drove. He was there, wasn't he?
She doesn't. I would object. That's beyond her knowledge. I was asking.
Hold on. Hold on.
Vigorously contest your honor. He was there.
Overruled. He has a right to cross-examine and she can answer. You don't answer for her.
Presenting her as a fact witness.
Sir, once again, you may be quiet while he speaks and don't speak over that person. You put her on. He is now going to cross-examine her.
And I would object that it goes beyond the scope of this here.
Overruled. The facts of cases.
She's not a fact witness. She's not being presented as a fact.
He's asking her if she is or not. Unless you were there,
I'm not presenting her.
Sir, are you going to argue with the court? I've already made my ruling. Overruled. Ask your next question. Thank you.
So you weren't there to see anything, were you?
No, I wasn't.
So the probable cause affidavit that's filled out by an officer who talked to the fact witnesses would be more apt to talk about the facts than you, wouldn't they? They'd be better. Okay. So if the fact situation says that your husband was there and that he was the one shooting because of the circumstances, you wouldn't be able to dispute that just from the facts, just by what you feel, right?
I don't know the facts, but I know how my husband is. I've been with him 42 years.
From what I hear, well, he's got several assault cases that he's been arrested for, hasn't he, over the years?
Must have been when he was a teenager because he don't do anything.
So
hold on. I'm going to clear the record up here. I don't see this in the public safety report or any other record.
There's no convictions. There's several arrests, so that's at least what I see.
Presumption of innocence is the standard.
Yeah,
okay. I won't consider it unless y'all got evidence that supports it.
So what I'm hearing, though, and I just walked in the middle of the hearing because I was outside the hallway, but you don't seem to have any resources to make a bond, do you?
No, actually I don't, but I can call family members if he get it low enough where he can. I'll try some kind of something to help him because he's sickly.
But you don't know what that is that you can get from the family members.
No, I don't.
Have you tried calling them about this bond?
Yes.
Okay. And they've all said, no, they can't help you.
Who can't pay $1 million bond?
I didn't ask that, ma'am. I asked, did they say they couldn't help you?
No, they can't.
Okay. So have you asked them what they could afford to help you with?
No, that's why we're here, so I could find out if it'd be lower.
So you haven't determined what amount your family members or friends could give you, is that right? Okay, I'll pass what it should.
Let me ask, can you elaborate a little bit about his health?
Rob, he would be in a better position to do that, Your Honor. I think I would present him for limited purpose and testify about his health. I did want to get his healthcare provider. I spoke to her on the phone, but HIPAA prevents her from testifying, is what she said. She consulted their attorneys. So she can't.
Go ahead.
What's your health condition? Well, what is it specifically?
I have asthma, COPD. I used to work construction. And I had asbestos in my left lung. I was working in Mobile here in Beaumont. I fell 30 feet off of the scaffold. I messed my back up, my back and my neck. I have chronic pain.
Why were you hospitalized?
Because my blood pressure, it fluctuated on them, and it was like 120 over 135 over 120. It was real high. And then the second time it was lower.
Yeah. What we do want to get accuracy, you're going to have I want to know what you may have to say. How are we doing?
I believe him to be legally, mentally competent, Your Honor. I've known Mr. Carter a long time, and I think that he is having some difficulties. I think that may relate more to pain, but I believe he's functioning mentally where we don't need a conference again at this point. That can change. If it does, then I'll price it more than that. But I believe right now he's mentally competent. He understands the nature of the charges against him. We've discussed the case. He's able to aid in his own defense.
When did you work last, sir?
In 91.
Oh, a long time ago. Over 30 years ago.
Answer out loud, Rob.
Yes, sir.
And then I think, what is the necrosis or the sore on your foot?
It's I got a hole in my foot. I went and took my trash cans out to the curb. But I have two of them, so I had to go back and forth, back and forth. When I finally went back through the back door, I seen my slipper on the top step. And I just put the slipper on, like I ready to get up to use the restroom, and there was blood on the floor. I rubbed a hole in the middle of my big toe. And it's been there for almost 3 years.
Yes, sir.
It's not healed, it's not right. It's closing, but it's still infected in the bone. I went to the hospital from the jail, and they wanted to cut my great toe off and the one next to it. And I told them, no, I didn't want to do that without asking my wife, because she's got better.
You still have all your appendages. I mean, they didn't do it. They didn't.
No. So because they wouldn't even let me. They wouldn't let me get in contact with her because of the situation of me being in jail. And they told me that I couldn't get in contact with her. I told them, well, no, I don't want to do it. So they put me on antibiotics, and they sent me back to the jail. Well, the jail didn't give me the antibiotics that I needed for my foot.
Yeah.
They said they waited like 2 weeks, then they gave me some antibiotics. Then it was just for a week or so.
How's your kidneys?
Kidneys, I have kidney stone.
The dialysis, you don't need dialysis right now.
No, sir. No, sir. They got me on medications. They said I'm liable to be on it for the rest of my life.
That's all we have. I'll put it in for Mr. Laird, who wants to cross it down.
Since you limited it, and the judge limited it to a question of his health, I'm not going to question one.
We rest.
Anything further from the stand?
Yeah.
What I want from the lawyers, I don't have a lot here in this file. I've got a probable cause affidavit that I tried to read, and would the parties be so kind to give me a synopsis of what your positions are of what you believe the fact situation is from your investigation?
Me first?
Yeah, you can go.
I believe that there's some evidence that Mr. Carter had some contact with the alleged victim prior to the incident. There is no direct evidence that he committed the homicide, the murder, other than the statements perhaps of co-defendants. I don't know if there's a GSR test done on his hand to see if he was the shooter, but I have reason to believe that the testimony of the co-defendants is not credible based upon his physical condition, his temperament, other things as well, but he would not have done what they're alleging that he did.
Go ahead, Steve. Judge, at the time of the offense, according to the statements from the witness and the detective, the defendant and another gentleman and the victim were all riding in a truck, driving down the road, saw a bicycle. They asked to stop to go get the bicycle, went back to back up. The defendant, one other individual, and the victim got out of the car. The person inside the truck heard gunshots, and then only the defendant and the co-defendant got back in the truck, and they drove off, and the victim was found laying there shot and dead later on. There was two different guns from the ballistics that show there were two different firearms used. And so due to the fact that two people got out, the man was shot, and there was two different guns used, and two different people got back in the truck. The detectives have placed, and the grand jury indicted them for murder of the victim in the case.
By way of brief response, the person that the state's relying on is on parole for murder. The driver's getting around, so I don't believe it's criminal.
What's the state's position on the motive by this?
I don't know that I have to prove a motive.
No, I'm not asking you that. Do you have any information on that? The motive is not
right
required,
now,
of course, but I didn't know if you had. I didn't see that in this probable cause affidavit.
My point is the person that they're relying on as a witness, Kevin Bryant, is on parole for murder. They're relying on the word of a convicted murderer to say to Mr. Carter.
We do that all the time. We do that all the time.
Well, I'm just saying that I believe that impacts credibility that the person alleging that Mr. Carter's murder is in fact a convicted murderer himself.
I understand. All right. Anything else to add by the parties? No. Anything else?
No,
okay. Go on. The court is
you can have a seat.
Well, the court makes a finding here that the evidence, it appears to be clear that the defendant was at the scene of the incident. What's not clear is what happened and what involvement the defendant may have had. The grand jury, of course, hears things in secret, so we presume that they felt like there was good faith in probable cause evidence, probable cause information to support the rendering of an indictment. The court is going to grant defendants relief or from $1 million to $500,000. If the defendant posts the bond, the defendant would be on home arrest, must have a GPS device, and would be subject to other conditions that would limit his ability to ambulate and move about. But the court feels like this is appropriate under the circumstances the court has before it.
Thank you.
What's our next event?
I was there for trial. I filed a motion for speedy trial.
Okay, thank you. That is all. Anything else from this docket? No, we're in recess. Where is?
All right. Motions.
Here, please. Oh,